Rwanda, dated the 12th of December 2023. The Abraham Index of Government, an independent organisation, rates Rwanda 12th out of 54 African countries. And the World Economic Forum Global Gender Group, GAPS, makes Rwanda 12th. The UK, by the way, is 19th. And the World Bank scored Rwanda at 16 out of 8, a maximum score of 18 in their quality of judicial processes. And finally, the World Justice Project on the Rule of Law ranked Rwanda first out of 34 sub-Saharan African countries. And those are points that I think tend to get overlooked in the debate that we're having, which tends to focus on our domestic arrangements. And that, my lords, takes me to my conclusion. The concept of the rule of law has featured prominently in our debate on this bill and will no doubt do so in the future. I'm not a lawyer, as many members of the House know, but nevertheless I strongly support the concept as an essential part of the freedoms we take for granted. But as I've also said in the past, the rule of law depends on the informed consent of the British people. And without that informed consent, the concept of the rule of law becomes devalued. So, my lords, when the House divides at the end of the debate, I respectfully say to members of your Lordship's House, we need to be careful not to conflate the fundamental importance of the rule of law with what I fear I see in these amendments, largely a measure of shadowboxing.
My Lords, I follow the noble Lord with much respect for him, for his contributions to your Lordship's House. The proposition made by my noble friend Lord Hope, which I support strongly, is that these amendments seek to give effect to the proposition that Parliament cannot judge Rwanda to be a safe country until the Rwanda Treaty has been and continues to be fully implemented. What does the government say? The government say that Rwanda is a safe country because the Rwanda Treaty has been achieved and shortly will be fully implemented. What are they afraid of in these amendments? For they simply seek to provide insurance for the proposition made by the government about Rwanda. Well, to answer that question, I would invite the noble Lord the Minister to remind himself once again of the report dated the 17th of January this year of the International Agreements Committee, which was discussed at some length in previous debates in your Lordship's House. And I draw his attention particularly to paragraph 45, which sets out 9 further legal and practical steps, that's the term of art that's used, further legal and practical steps, which are required under the treaty, which will make, in the opinion of that committee, Rwanda a safe country, which operates the treaty in the way in which is intended by its words. And I would ask the noble Lord the Minister, who has been challenged to this effect before, to tell us quite specifically how many of those 9 requirements in that paragraph have now been implemented, which they are, and in relation to the ones that have not yet been implemented, when they will be implemented. And if the situation is that the government's optimism is such that, as the noble Lord Murray said in an earlier intervention in this debate, it's enough to go into the Rwandan Parliament and see that the treaty has been ratified, not the requirements in the committee's report. If it's enough for that to be a way of regarding the bill to be justified, what is the intellectual basis for that conclusion? Because I see none, unless these requirements can be demonstrably implemented in full. Rwanda is not a safe country. And this insurance policy proposed by my noble and learned friend is exactly what's needed unless we are told of full implementation.
I invite us really because of the speech of Lord Hodgson. because he suggested that those of us who have worries about this bill are in some way wanting to stop anything of this kind. I just want to make it absolutely clear. I don't have a theological or philosophic objection to the concept that you might have a system which involved some other country in order to deal with these problems. My problem is very fundamentally this. I hope in all the years as a minister and as a member of Parliament, I never told a public lie. And I am being asked here to tell a lie, because the government has told us that Rwanda is not a safe place at the moment, but is going to be a safe place. Indeed, the minister himself explained that to us. But they are asking us to say it is a safe place now. And at the same time, they are pointing to the Supreme Court and saying it is perfectly reasonable to disagree with the Supreme Court because the information which we now have makes a decision now different in kind from the one that they made, because they didn't have that decision. So evidently, it was perfectly right for the Supreme Court to say it wasn't a safe place then, but now we're in a different position. But the government hasn't provided us with any of the evidence which makes that different position tenable. All the government has done is to say, we have signed an agreement, that agreement is going through, and we are in the course of ensuring that that agreement is carried through in Rwanda. Now, I don't much mind how we do this, but what I want to be able to do is to vote to say Rwanda would be a safe place if all these things are carried through, and I want also to make sure that there is a mechanism for checking that, and I also want to make sure that if it should change, and after all, governments change. Africa has been known to have very significant changes. Indeed, the present government of Rwanda is a very, very hopeful change from what they had before. So we need to have a mechanism whereby, should the situation alter, we would be able to deal with that. Now, normally, the courts would be able to deal with that. But the government has specifically excluded the courts, and therefore we need to have something of this kind. And I do think that the mover of these motions is absolutely right in saying they can all be carried through without holding up this act. So I want to ask my noble friend very directly, given this is not going to hold anything up, given that he's going to allow himself to tell the truth instead of not telling the truth, given that he can allow me to tell the truth, why doesn't he just allow us to do it? Many of the other issues are of high political and legal concern. This is a terribly simple, basic fact. Will you allow us to say that Rwanda is a safe place when you can provide the information to allow us to tell the truth? For goodness sake, let's tell the truth.
Well done, John.
I also, as a member of the Joint Committee on Human Rights, was in Rwanda very recently. We had a packed program, and everyone we met told us that Rwanda is a safe country. And this includes women's rights, the LGBT organization. They all told us that that's how they felt. We were also told that Rwanda has the largest LGBT community in Africa, and many people from that community flee neighboring countries to come to Rwanda because they feel safe. Critics also tend to overlook the fact that Rwanda has one of the lowest levels of corruption in Africa, and that it is committed to the rule of law. It has more women in the participation in the labor market than in any countries in Africa. And the Supreme Court's decision, mainly based on the UNCHR report, failed to take many of those facts into account. The UNHRC representative we met admitted that Rwanda was at the forefront of improving its legal system, that Rwanda was a safe country as such, but not safe to accept relocated individuals from the UK, as the current system was not capable or experienced enough to deal with them. My lords, I need to point out that this was before this new agreement, where a lot of the concerns from the Supreme Court have been addressed. She also pointed out that refugees from the UK came from different backgrounds to refugees from neighboring countries. That comment was in direct contradiction to all the positive attitudes we witnessed. Everyone we met expressed genuine readiness to accept and welcome the refugees from the United Kingdom. The UNHRC representative conclusion was, which I found most revealing, was that the UK should accept all immigrants arriving to their shores rather than sending them off to Rwanda. But my lord, this is unrealistic to say that UK has a responsibility to accept all the asylum seekers, particularly if they come to our shores for economic reasons, and line up the pockets of traffickers. We are one of the most generous countries when it comes to refugees, but we have a responsibility towards our citizens, and this includes securing our borders to ensure that no one takes advantage of our system. My lords, most of the people we met in Rwanda were surprised, if not deeply hurt, by the negative attention their country has received from both houses and the media. And I have to tell you that I was embarrassed. I felt that here we are criticizing that country that has had the terrible genocide in the past, and in the past 30 years they have done so much to improve everything, and they are so willing to accept new migrants. I was embarrassed. And to be honest, Kigali is a beautiful country. I fell in love with it. A beautiful city. It is clean, it is tidy, it is well organized, it's a young population full of optimism, looking forward to their future. And I wouldn't mind living there, to be honest. And my lords, I would actually recommend that a lot of you who criticize Rwanda would actually go there and check for yourself and decide what you think, rather than making observation on hearsay and possibly, yeah.
Before the noble lady sits down, she referred to LGBT situation in Rwanda. Before the noble lady responds, let me perhaps pose my question. Could she indicate to the House the LGBT organisation that she met with?
We met two of them. We met the Rwanda sorry, my memory is not so good, you see. Rwanda Women's Network, which was very actually interesting. Hope and Care Organization, Rwanda Men's Resource Center, and the other organization was My Rights Alliance organization. And they're both campaigning for LGBT rights.
I thank the noble lady for that, and I won't detain the House any longer, but I think it's important to put on the record, and I say this with some knowledge of Rwanda, having been the chief election observer for the European Union in Rwanda in 2008 and subsequent knowledge since. However, she quoted the Hope and Care organisation, and it does indeed do a great deal of work, but I thought your lordships should be aware of a recent quote, and I won't name the individual for fear of placing anyone at risk, but it is on my records, if anyone needs it, and I quote, "Homosexuality is not criminalised in Rwanda, but many LGBTI people keep their sexuality and gender identity secret in an attempt to avoid rejection, discrimination and abuse, which in the long run inevitably denies them their basic human rights." Close quotes.
I just want to comment. I'm not an LGBT, so I have no idea, but from the evidence we heard, apparently in the older generation or in the countryside, it's also a little bit frowned upon, probably like in the United Kingdom. But that similarly in Kigali, the capital, we were told that actually two men walking in the street holding hands is absolutely fine. This was the report we received.
Again, I won't detain the House, but I will refer to this particular situation and the expression of one's sexual identity in a later grouping, Group 5. Thank you. I thank your lordships for your patience.
Might I briefly add a few comments to the remarks made by the noble Lord Gummer? In his remarks, the noble Lord Hodgson said, and it is true, that there is a lot of concern and anxiety about the whole issue that we are discussing this afternoon. My lords, probably in this chamber, there is nobody who knows less about Rwanda than I do. And I dare say I am representative from the nation as a whole. It would, I think, be a great deal of advantage for everybody, because the wider world is very concerned about this, and we've been talking about this from the perspective of this chamber. If you look at it from the perspective of the wider public, to have something along the lines of what the noble Lord Hope and the noble Lord Anderson are advocating would be very helpful in trying to allay wider public concern. Because it seems to me, my lords, and I'm sure we all regret it very much, but the way the world is now, the fact that government gives it the thumbs up does not necessarily instill great confidence in the wider public.
My Lords, I think I'd like to start by saying to Lord Deben why I come to the same conclusion about these amendments, but perhaps from a different perspective, because as you know, these benches voted against the bill in principle, but that doesn't mean to say that we, having not won that argument, that we won't support changes to the bill in ways which mitigate the problems which we still see with this bill. It is worth reminding the House of the decision that this House took in respect of the treaty, which, as it said, we will not recommend the treaty be signed until these conditions are in place. Now, as you know from the standing orders of this House, that is a resolution of this House, and it is the view of this House. So simply, these amendments are seeking to amplify and to recognise the decision of this House which is in place at the present time. Because if it's not in place, then we're going to be asked to do that fictionalised thing, which is basically to change our minds from what we said before, that we need to have those in place before we can see it as safe, and now we would change our minds and we would have to do it simply because the bill is before us. So what this group of amendments does is to recognise that we need to have them in place before the consideration this House has already given can be reversed. And I must say to the noble lady that safe in respect of a country is not about the beauty of the country or the nature of the people. It's about the structures and the systems which they have in place in order to meet their obligations and meet obligations for refugees as we have laid out. Now, my lords, given that the courts have made a decision of fact on the safety of Rwanda, it's deeply problematic that the government wants this Parliament to overturn its own decision and declare the opposite. And if that were the case, we would have thought that they would be better off going back to the courts to review the evidence and coming to a finding of fact if it believed the situation had changed. But as the United Nations Council for Public Affairs and the recent announcement that we've heard from them last Friday said, this bill will unduly limit judicial independence by requiring judges to treat Rwanda as a safe third country now and in the future, regardless of any evidence to the contrary before them. Now, it's clear that the terms of the treaty have not been met. That's what this House says. That is the resolution of this House. They need to be met before the requirements of the treaty are satisfied. The mechanism by which the government is asking Parliament to declare Rwanda safe is the treaty. Now, the Minister confirmed during committee stage that indeed the safeguards, as outlined in the resolution of this House, are not yet in place, but are being worked towards. The Hansard of the 12th of February, day one, my noble friend Lord Purvis asked, can we pursue the issue that the Minister had said, is what the Rwanda government are working towards putting safeguards in place? That means they're not currently in place. Is that correct? And Hansard says that Lord Stewart of Dillon, noble Lord the Minister, noble Lord the Minister said it must do. Now, this afternoon, letters have been delivered to members who took part in these debates, and I apologise for having to look on my phone because these letters, which related to the committee of this House on this bill, were only delivered by electronic mechanisms after we had started discussing the report. Now, that is not the way I think this House should be treated. If we want the evidence upon which we can make decisions, we should have had it in time to be able to make further progress. But anyway, my lords, I have to turn it sideways because it is very small writing, but I can do my very best. It says in one paragraph about whether these matters are in sight. It said the Rwandan Treaty, the UK-Rwandan Treaty, sorry, I've got to find the right sentence, it keeps jumping too small. The UK and Rwandan governments will continue to work closely together to implement all the measures under the treaty and prepare to operationalise the partnership. So quite clearly, the facts that were required by this House are not there at present. It's almost, and I do like to quote Lord Purvis, his analogy, it's like saying, right, gentlemen, ladies and gentlemen, we're going by plane and we're working towards making the plane safe. Now, if you think about it, that's where we are at the present moment. Would you get into that plane? Probably not. You'd be foolish to do so. But if you did get into it, you have no guarantee that it would be capable of, first of all, flying or even dropping out of the air. So these resolutions, these amendments are absolutely clear that we must put them in place. They've already been agreed by this House, who've made it clear the conditions that we as a House place on the treaty are to be adhered to. They make it clear that the conditions and procedures they must adopt to satisfy the House both before and after deportations can take place. They are sensible. They are what the House requires in order to fulfil the requirement of the decision that we took on the matters of the treaty. My Lords, I support.
My Lords, I do urge noble Lords to use some common sense. It is inconceivable, if this Act is passed, for the first few months, regardless of whether all the conditions of the treaty have been implemented, that Rwanda, under the full spotlight and glare of international publicity and the attention of this press, that Rwanda will not implement carefully and considerately, will not refool anyone that we send them. The reason for having all the things in the treaty is for the period after the initial spotlight has been turned off, after attention has waned. then it's important to have all those considerations in place. It isn't initially, and no one could really imagine that we send someone out and within a few weeks they're sent by Rwanda to some unsafe country. It won't happen. We know it won't happen. But it is very important that we get this happening soon. Not only use common sense, but be merciful. Because the longer we delay, the more people will come across the channel and the more will die.
My Lords, I wonder whether the Minister would care to comment on whether he agrees with the Noble Lord Lilly's analysis of the status of this bill which we're debating here. Lord Lilly said it's inconceivable that there would be any refoulement, and that it's okay to proceed without the various recommendations in place, because in the longer term they would need to be in place, because it was in the longer term. I think Lord Lilly was suggesting that there may be justification in the suspicions which are being raised. I think that's the point which the Noble Lord Lilly was making. But, my Lords, I want to speak very briefly to say that I would like to thank the Noble and Learned Lord Hope for tabling these amendments and his very constructive communication ahead of putting them down. There was a clear interest at committee stage of the bill in developing a mechanism to ensure that the terms of the treaty are adhered to and continue to be adhered to. And I hope that the House will see that there's a value in how Lord Hope has integrated these ideas into the amendments tabled here. Amendments 4 and Amendment 7 together provide a clear framework for ensuring the ongoing safety of Rwanda, rooted in the terms of the treaty which the government itself has negotiated. My Lords, I'm not going to say any more because I think the Noble and Learned Lord very clearly set out the terms of his amendments.
My Lords, I'd like to thank all Noble Lords for their contributions. The partnership between the UK and Rwanda is rooted in a shared commitment to develop new ways of managing flows of irregular migration by promoting durable solutions, thereby breaking the existing incentives that result in people embarking on perilous journeys to the UK. And we saw again how perilous those journeys are only last week, as my noble friend Lord Hodgson noted. The UK and Rwanda share a vision on the need for the global community to provide better international protection for asylum seekers and refugees, emphasising the importance of effective and functioning systems and safeguards which provide protection to those in most need. Noble Lords will know that Rwanda has a long history of supporting and integrating asylum seekers and refugees in region. For example, through its work with the United Nations High Commissioner for Refugees to host the Emergency Transit Mechanism. It has also been internationally recognised for its general safety and stability, strong governance, low corruption and gender equality. Again, as my noble friend Lord Hodgson noted, and I thought as noble Lady Baroness Mayer gave us her very welcome perspective on her recent visit. And I would say gently to the noble Lord German, I heard a great deal in her comments about structures and systems. My Lords, as the noble Lord Hope of Craighead has explained, these amendments seek to only allow Parliament to deem Rwanda to be safe so long as the arrangements provided for in the Rwanda Treaty have been fully implemented and are being adhered to in practice. The UK government and the government of Rwanda have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. In advance of agreeing the treaty, we worked with the government of Rwanda to respond to the findings of the courts by evidencing Rwanda's existing asylum procedures and practice in standard operating procedures relating to and reflecting the current refugee status determination and appeals process. Amendment 7 imposes a duty on the Secretary of State to obtain a statement from the Independent Monitoring Committee confirming that the objectives specified in Article 2 objectives of the treaty have been secured. My Lords, this is unnecessary. The government will only ratify the treaty in the UK once we agree with Rwanda that all necessary implementation is in place for both countries to comply with the obligations under the treaty. We have assurances from the government of Rwanda that the implementation of all measures within the treaty will be expedited, and we continue to work with Rwandans on this. Just last week, the legislation required for Rwanda to ratify the treaty passed the lower house of the Rwandan Parliament on the 28th of February, and it will now go to the upper house, as my noble friend Lord Murray noted in the previous group. Once ratified, the treaty will become law in Rwanda. So it follows that the government of Rwanda would then be required to give effect to the terms of the treaty in accordance with its domestic law as well as in international law. My Lords, the bill provisions come into force when the treaty enters into force, and the treaty enters into force when the parties have completed their internal procedures. These amendments therefore confuse the process for implementing the treaty with what is required for the bill provisions to come into force. This bill builds upon the treaty between the UK and the government of Rwanda, signed on the 5th of December 2023. The bill reflects the strength of the government of Rwanda's protections and commitments given in the treaty to people transferred to Rwanda in accordance with the treaty. The treaty, alongside the evidence of changes in Rwanda since the summer of 2022, which was published in January of this year, will enable Parliament to conclude that Rwanda is safe, and the new bill provides Parliament with the opportunity to do so. And I would say to my noble friend Lord Deben that that is the truth. Turning to the points raised.
Everything that he says, I accept. But it's all about what's going to happen in the future. What he's asking me to do is to say that what is going to happen in the future has happened now. That's the only argument. And he wouldn't ask me to do that in any other circumstances. Could he explain why I've got to do it now?
Because of the point I made.
Well, my Lords, I think I've been extraordinarily clear on this particular subject. As I said, the bill provisions come into force when the treaty enters into force. The treaty enters into force when the parties have completed their internal procedures. And these amendments, therefore, confuse the process for implementing the treaty with what is required for the bill provisions to come into force.
Well, my Lordship, he says it will confuse it. It's actually perfectly straightforward. If everything happens as he says it will happen, and I hope it does, because I don't object to the safe country policy that's being pursued if you can find a safer country. But if everything happens as smoothly as he says it's going to do, then the monitoring committee will presumably confirm that it's happened. Why is he resisting it, except to save the Secretary of State having to send a letter asking for the monitoring committee's principle? Why is this amendment a threat to the government's stated policy?
I would say to my noble friend, I'm about to come on to the workings of the monitoring committee in great detail, so if he will bear with me. So turning the points raised with regards to introducing a duty on the Secretary of State to consult with the monitoring committee every 3 months during the operation of the treaty. My Lords, this committee is independent of both the UK and Rwandan governments. It was always intended to be independent in order to ensure that there is a layer of impartial oversight of the operation of the partnership. Maintaining the committee's independence is an integral aspect of the design of the policy, and as my noble friend Lord Stewart of Durlton set out, the treaty enhances the monitoring committee's role. It will ensure obligations to the treaty are adhered to in practice, as set out in Article 15(4)(b). It will report to the Joint Committee, which is made up of both UK and Rwandan officials. As per Article 15(4)(c) of the treaty, the Monitoring Committee will make any recommendations to the Joint Committee which it sees fit to do. Therefore, these amendments are both unnecessary and risk disturbing the independence and impartiality of the Monitoring Committee.
Confirm to the House that the Minister, which I assume means the Secretary of State for Home Affairs, will not seek to bring this bill into force, or the Act into force, until he is satisfied that all the provisions of the treaty have been implemented and are being properly operated.
Noble and learned Lord, that I think I've already answered that. The bill provisions come into force when the treaty enters into force, and the treaty enters into force when the parties have completed their internal procedures.
That's not quite an answer to my question. Could he give the House an assurance that the Home Secretary will only bring the treaty into force once he is satisfied the treaty's provisions have been implemented and it's operational?
I disagree. I'm afraid that is an answer to this particular question. I think it is. To assure noble lords further, the Joint Committee met on the 21st of February to discuss implementation and readiness for operationalisation and, as set out in the published terms of reference for the Joint Committee, minutes will be produced after each meeting for agreement by the co-chairs. The Monitoring Committee will undertake daily monitoring of the partnership for at least the first 3 months to ensure rapid identification of and response to any shortcomings. This enhanced phase will ensure that comprehensive monitoring and reporting takes place in real time. As I set out in earlier debates, during the period of enhanced monitoring, the Monitoring Committee will report to the Joint Committee in accordance with an agreed action plan to include weekly and bi-weekly reporting as required. During this enhanced phase, the Monitoring Committee will place particular emphasis on monitoring asylum procedures, asylum case assessments, and any asylum decisions made in this timeframe. The Monitoring Committee will ensure that decisions are objective and based on a legally sound foundation in accordance with international laws and convention. The following minimum levels of assurance have been agreed by the Monitoring Committee for the enhanced phase. 2 visits to the UK to see the selection process, observing 2 boarding and 2 disembarkations, observing 3 induction sessions, weekly visits to accommodation and reception centres, monthly visits to health facilities and education, observing education and language training sessions, observing interviews, observing appeal hearings, reviewing the process and paperwork for all individuals relocated to Rwanda in this phase, monitoring the status of people relocated to Rwanda, captured through the quarterly reporting process and visits to resettlement areas, review a sample of at least 25% of complaints, including all serious incidents, investigating all complaints received directly, interviewing on a voluntary basis a sample of 1 in 10 relocated individuals at various stages of the process. The published terms of reference are accompanied by a detailed monitoring plan as agreed by the Monitoring Committee, which was published on the 11th of January. These documents provide a comprehensive and transparent framework for the operations and procedures of the Monitoring Committee, starting from the immediate departure period of the first cohort of relocated individuals and including the details of the enhanced initial monitoring phase. The plan provides an overview of the Monitoring Committee's specific activities, monitoring techniques, and the personnel involved. It also outlines reporting procedures and...
I'm most grateful to the Noble Lord who's given us a great deal of new information about the Monitoring Committee, but all that he's told the House demonstrates the Monitoring Committee is extremely well placed to provide the government with the information it needs to act as in my noble and learned friend's amendment. So what's holding it back? The fact of the matter is that the Monitoring Committee has no means of reporting to this Parliament, but the government does. And that is what this amendment suggests is the right thing to do.
What the Noble Lord says, but I think I've answered again this in considerable detail now. My Lords, this...
The more detail the Noble Lord gives about the virtues of the Monitoring Committee, the stronger his argument is in favour of the amendment proposed to this House by Lord Hope. This briefing he's been given is totally contradictory to the conclusion that he's trying to invite us to reach.
I'm afraid I disagree again. My Lords, as set out in the monitoring plan, the Monitoring Committee will ensure that there is a daily presence of the support team on the ground through the initial enhanced phase. And for the enhanced phase, a minimum of 2 Monitoring Committee members will be actively engaged in the monitoring. My Lords, implementation continues at pace, including the support team for the Monitoring Committee and the new appeals body. So I would like to put on record my thanks to all officials, including those in the Government of Rwanda, for all their hard work in implementing the treaty and delivering the crucial partnership. The partnership is one important component of a much broader bilateral relationship. We cooperate closely with Rwanda on a number of issues, including the Commonwealth, climate change, education, trade, governance and conflict issues, and delivering a successful and long-standing development partnership. So to conclude, we have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. These assurances and commitments provide clear evidence of the Government of Rwanda's ability to fulfil its obligations generally and specifically to ensure that relocated individuals face no risk of refoulement. I therefore respectfully ask the Noble Lord...
Before the Noble Lord sits down, can I return to the question I asked him? Will he now tell the House which of the 9 provisions highlighted in paragraph 45 of the International Agreements Committee's report are now completed?
This has already been discussed. The lower house of the Rwandan Parliament has only passed its treaty ratification earlier this week, and as I have just tried to explain, implementation continues at pace. I don't have the very specific information he requires yet, but as I've also explained, we will not be implementing until all of the treaty obligations are met. I would therefore respectfully ask the Noble Lord to not move his amendment, but were he to do so, I have no hesitation in inviting the House to reject it.
I'm very grateful to all noble lords who've taken part in this debate. I don't want to take up time by going over the issues all over again, but I wanted to pick up just 2 points made by the noble Lord Hodson of Astley Abbott. First of all, I think he suggested that my amendments were treating Rwanda as a country which is untrustworthy. The Lords, I absolutely refute that. When I introduced these amendments at committee, I made it absolutely clear that I do not for a moment question the good faith of Rwanda, and I remain in that position. I absolutely understand that both parties to this treaty are treating with each other on that basis, and certainly I'm not in any way questioning good faith or indeed the commitment of Rwanda to give effect to the treaty. What I'm talking about is its implementation. The second point is, I think he said that my amendment would make the bill unworkable. Lord, I simply do not understand that. I cannot understand why relying on the word of the monitoring committee in any way undermines the effectiveness or purpose of this bill. For these reasons, my Lord, I wish to test the opinion of the House.
I must advise the House that if Amendment 4 is agreed to, I cannot call Amendment 5 due to preemption. The question is that Amendment 4 be agreed to. As many as are of that opinion will say content. Content. The contrary, not content. Not content. The question will be decided by a division. I will advise the House when voting is open. My Lords, voting is now open. Clear the bar.
The question is that Amendment 4 be agreed to. As many as are of that opinion will say content.
Content.
The contrary, not content.
Not content.
The contents will go to the right by the throne, the not contents to the left by the bar. The question is that Amendment 4 be agreed to. My Lords, there have voted contents 282, not contents 180. So the contents have it.
What's that? It was 100 last time, 100.
My Lords, Amendment 4 having been agreed to, I cannot call Amendment 5 due to preemption. Amendment 6, the Baroness Chakrabarti.
6. So, my Lords, I apologise, I'm slightly confused because I thought there was another vote
That puts you in the majority.
in the previous group, but apparently not. So, in the absence of my noble friend Lord Blunkett, I'll briefly open this group. I share amendments. No. What am I? Well, then why am I on my feet?
Not moved. When you say not moved, they move on to 7.
Does the noble Baroness wish to not move her amendment?
Yeah, not moved. Not moved.
Not
moved.
It's not. I'm not moving Amendment 6. That's right.
Amendment 6 not moved. Amendment 7, the Lord Hope of Craigie.
I wish to test the opinion of the House on this amendment.
The question is that Amendment 7 be agreed to. As many as are that opinion will say content.
Content.
The contrary not content.
Not content.
The amendment will be decided by division. I will advise the House when voting is open. My Lords, voting is now open. Clear the bar.
The question is that Amendment 7 be agreed to. As many as are of that opinion will say content. Content. The contrary not content.
Not content.
The contents will go to the right by the throne, the not contents to the left by the bar. Speaker, the question is that Amendment 7 be agreed to. There have voted contents 277, not contents 167. So the contents have it. My Lords, before I call the next amendments, I will explain the order of preemption, because it's important. If Amendment 8 is agreed to, I cannot call Amendments 9 to 11 due to preemption. If Amendment 9 is agreed to, I cannot call Amendments 10 to 11 due to preemption. If Amendment 10 is agreed to, I cannot call Amendment 11 due to preemption. I will remind you at the relevant points. I now call Amendment 8. I would remind you for Amendment 9 that if it's agreed to, I will be unable to call Amendments 10 to 11 due to preemption. Amendment 9.
My Lords, I rise to address Amendments 9 and 12 in my name and those of the Noble Lord Carlisle, the Right Reverend Prelate, the Bishop of Manchester, and the Noble and Learned Lord Clerk of Nottingham. I will be brief because these equivalent amendments were discussed in detail in committee. I should say I'm also very grateful to the Noble and Learned Lord Hope of Craighead for how he has dealt with the issue of preemption, which I hope, your Lordship's willing, may allow both groups of amendments to stay alive. Amendment 9 would allow ministers, officials and courts to depart from the presumption that Rwanda is safe when presented with credible evidence that it is not. Amendment 12 would remove various detailed barriers to that course. Their combined effect is to reverse two of the most revolutionary aspects of this bill, and I do not use that word in a positive sense. They are the requirement that decision makers, including courts, must stop their ears to any evidence that does not agree with the government's position, and the requirement that they should do so for an indefinite period, even if things in Rwanda should, as we all hope they will not, take a turn for the worse. If noble lords are in any doubt as to how truly remarkable Clause 2 is, I would invite them to look at subsection 4. It doesn't matter how compelling your evidence is of what could happen to you and people like you when you get to Rwanda, it must not even be considered if it questions the proposition that Rwanda is safe. And at subsection 5, which sets out the legal principles that have to be ignored in order to make this clause work. Not just the Human Rights Act and international law, but, and I quote, any other provision or rule of domestic law, including any common law. An insight into the sheer range of legal protections, ancient and modern, that may have to be disregarded in the interests of avoiding the impartial scrutiny of the courts. If Rwanda is safe, as the government would have us declare, it has nothing to fear from such scrutiny. Yet we are invited to adopt a fiction, to wrap it in the cloak of parliamentary sovereignty, and to grant it permanent immunity from challenge, to tell an untruth and call it truth. Why would we go along with that? Clause 2 of the bill, my lords, takes us for fools. Subject to anything the Minister may say, when these amendments are called, I fully expect to test the opinion of the House. I beg to move.
Amendment proposed, Clause 2, page 2, line 34. At the end, insert the words as printed on the Marshall list.
Oh, sorry.
My Lords, I rise to offer support to the noble Lord Anderson of Ipswich, and I'm really glad that this evening I've started to understand the processes of the House of Lords, having been here for only 8 years. So I will not speak to Amendment 6, which had to be withdrawn in order to vote on Amendment 7, even though Amendment 6 was in Group 3. But there we go. I can be even briefer than I intended to be by just saying when something is a nonsense, it remains a nonsense at whatever stage we happen to be voting on. And that crucially, and in terms of what Lord Anderson has rightly said, that when circumstances change, most people change their minds. But if minds are not allowed to be changed when circumstances change, then we're all extremely foolish. I heard the noble Lord Howard on the radio this morning explaining in great detail why Parliament had primacy over the courts, and in many respects, as with the doctrines of Lord Jonathan I can't get my teeth round. Sumption. I agree. But actually, what happens when the government step outside the norms of international conventions which Parliament has ratified and signed up to, then the courts obviously continue to have a substantial role, because that's the checks and balances that we built in. So what we're trying to do, I think, this evening is to try and make some sense of a nonsensical piece of legislation. And no doubt the House of Commons will just nod through the government's rejection of these amendments. But actually, in time to come, when historians look back, I think they will ask the question, where were you and what did you do? And if you can't answer that in a way that makes you feel comfortable about your grandchildren seeing it, then don't do it.
Lords, what a privilege to follow my noble friend Lord Blunkett, and I apologise to your lordships for my mistakes earlier on with standing up at the wrong time. I have Amendment 19 in this group with the noble and learned Lady Baroness Hale of Richmond, the noble Viscount Hailsham, and the Right Reverend Prelate, the Bishop of St Edmundsbury and Ipswich. However, I commend all other amendments, and in particular, I commend the simple and clear amendments of the noble Lord Anderson of Ipswich. Because while we suggested a rebuttable presumption, his formulation that a finding of safety may be displaced by credible evidence to the contrary is clearer and even more attractive. So I do urge the noble Lord Anderson, as he's indicated, to please press his amendment to a vote. And in concluding, I merely flag as a sort of advert for Wednesday that it is very, very important that as many noble lords as possible could be here early on Wednesday to support Amendment 33, which is the new Clause 4. That it will be debated and pressed then, because without that amendment that restores the general jurisdiction of the courts, other amendments, even these ones, could well be illusory. The purpose, as I say, to restore the jurisdiction of courts and tribunals, to decide what are the facts based on the evidence before them, including to invoke this rebuttable presumption, is what our courts are for, despite all the dancing that we heard before about novel interpretations of the rule of law. Our courts are admired for that jurisdiction all over the world. That is what we mean by the rule of law.
Rise briefly to support what the noble Lord Anderson has said, and of course the noble Baroness, I signed her Amendment 19. I do think that this House should try to insist that if the facts change, a mechanism is provided to the courts to reassess the situation. Anything else is profoundly unjust, and therefore if the noble Lord Anderson moves his amendment, I should be supporting him.
My Lords, as well as supporting the noble Lord Anderson, I rise to speak to Amendment 16, which seeks to minimise the risk of torture arising from the bill and to safeguard those who are torture survivors. I'm grateful to the noble Baroness Lady de Souza and my noble friend Lord Cashman for their support, and they'll speak to the first part of the amendment while I focus on the second. We brought it back because of our dissatisfaction with the response from the noble and learned Lord the Minister in committee, and we hope we might do better now, given the existential importance of torture, which represents one of the most serious of human rights violations. We know from the work of organisations such as Freedom from Torture and Redress, whose help I'm grateful for, that a good number of the asylum seekers in line to be sent to Rwanda will have survived torture. We also know, including from a recent report from the Mental Health Foundation, that the high incidence of mental health difficulties among asylum seekers, the risk of which is increased by traumatic experiences such as torture. These difficulties can only be exacerbated by removal to Rwanda. My Lords, in committee, the Minister pointed out that an individual could challenge removal on the grounds of their individual circumstances, but Freedom from Torture warned that providing in the time available the necessary compelling evidence to meet what is the exceptionally high bar set by the test means that it does not offer torture survivors an effective safeguard. Indeed, the Minister himself admitted that successful claims on this basis are expected to be rare, and that might have implications for some other amendments. In response to my questioning about what mental health support will be available to torture survivors in Rwanda, the Minister referred me to Article 13 of the treaty, but that refers only to the special needs of victims of modern slavery or human trafficking. I can find no reference to the needs of torture survivors. My noble friend Lady Kennedy of the Shores interjected that the mental health situation in Rwanda is very poor, with high levels of mental illness, but very few suitably trained medical professionals. Since then, I've been referred to WHO's 2020 mental health profile for Rwanda. This confirms the low level of provision and seems to show that there are no outpatient mental health facilities. If this continues to be the case, would traumatised torture survivors have to be admitted to a mental health unit to obtain any support? As was noted in committee, civil society remains weak and therefore is unlikely to be able to step in. More recently, last October, a press release from Interpeace, while commending the efforts the Rwandan government have made in this area, warns that the country still faces challenges such as the scale of mental health needs that outstrips the capacity of available professionals, low awareness and knowledge of mental health issues, poor mental health infrastructure. My Lords, from his responses, it would appear that the government simply don't know what support will be available and have made no attempt to find out. Yet they are happy to condemn this highly vulnerable group to a life in a country that, with the best will in the world, is ill-placed to provide that support. Of course, ideally, I would want the government to accept the case for not sending torture survivors to Rwanda. But at the very minimum, I would ask the Minister, I'm not quite sure which Minister I'm speaking are, I would ask the Minister to take this issue back to the Home Office and give an undertaking that he will ask his colleagues to talk to the Rwandan government about support for torture survivors and, if necessary, provide the necessary resources to ensure that support is available, perhaps earmarking part of the enormous sum to be paid to Rwanda identified by the NAO.
What needs to be said about the risk of torture and inhumane treatment has already been set out by the Noble Lady, Lady Lister. I simply wish to emphasise the credibility of the reports of ongoing torture, of even mild political dissenters that continues to this day in Rwanda. And nor, my Lords, does freedom of expression and association exist in Rwanda, however narrowly the term is defined. However, the genocide ideology law is very broadly defined and carries now criminal sanctions. The criminal code has recently been expanded to include creating a hostile opinion of Rwanda by criticising the government. So these irrefutable reports indicate that Rwanda does not comply with the international obligations under various UN conventions, including the Convention Against Torture, and this can only add to the evidence that at present Rwanda cannot be regarded as a safe country.
Grateful to the Noble Lord Anderson of Ipswich for sponsoring amendments 9 and 12, to which I've added my name, that take up matters that we also raised at committee stage, myself and the Noble Lord Carlisle. This particular evening, Rwanda may be the safest country in Africa, for all I know, but we have seen over the last few years a number of military coups, a number of takeovers across African countries to enshrine in legislation the notion that Rwanda will remain safe. Whatever seems to me to beg a belief. Who knows what that state that country may be in 6 months' time, in 12 months' time? Who knows how safe it will be then? The courts need to have the ability to take new facts into consideration, to recognise that Rwanda may not be the same in a certain number of weeks or months' time or years' time as it was on this particular evening at the beginning of March 2024. We must have that flexibility. So I hope Lord Anderson will press these amendments for division, and I will support him in the lobby if he so does.
My Lords, as a member of the JCHR delegation, I had the benefit of visiting the very hospital in Kigali, which will provide mental health support to relocated individuals. It was, my Lords, an impressive experience. That particular hospital has very capable psychiatric and psychological care. And this is perhaps unsurprising given the context in which Rwanda finds itself. This is a country which 30 years ago was caused mass trauma as a consequence of the genocide against the Tutsi, which cost 800,000 lives in Rwanda. You can imagine, my Lords, the impact that has on the relatives and those who knew those 800,000 people. Mental health is a widely understood and widely acknowledged health issue in Rwanda. The community schemes to work on mental health are abundant. This is a country which understands mental health. The points raised against Rwanda on the basis of mental health are, in my view, unfounded. And I do not accept the contentions advanced by the Noble Baroness Lady Lister and the Noble Baroness Lady de Souza.
I just want to follow the Noble Lord Murray in terms of him trying to portray the issue of mental health provision within Rwanda. And to use his words, the understanding of the illness may be there, and the provision, he says, is significant. My Lords, I just want to point out that in the UK, in terms of psychiatrists, there are 13,170, which equates to 1 for every 5,200 citizens. In Rwanda, what the Noble Lord Murray didn't tell the House is that there are only 15 psychiatrists in the whole of Rwanda, which equates to 1 for every 953,000 people. So the provision clearly isn't on the ground. The number of clinical psychologists are not known, but the latest evidence is it probably runs into less than 200. The people who are vulnerable and who are critically scarred mentally will need the use of both psychologists and psychiatrists. And the fact is they are not there on the ground. So when Lord Murray presents his views of what he has seen, they are important, but they must be put in the context of exactly what provision is on the ground in Rwanda. And mental health, even though the government may wish to see it as a provision that is important, the fact is the provision isn't on the ground to treat people already in Rwanda, never mind people who will be going from this bill.
My Lords, as I said earlier when talking to a group of amendments, I spent a great deal of time in Rwanda, and of course, as anyone knows who visits there, the first thing one does is one goes to the Genocide Museum to look at the faces of those who were lost, to look at the skulls that are there to remind us that it should not be forgotten. Indeed, my Lords, the genocide strikes at the very psyche of Rwanda and laws within Rwanda. And it is because of our very deep concerns and for the progress that Rwanda has made that we put forward these amendments based on safety for whom we believe are amongst the most vulnerable in the world. My name has been added to the amendment in the name of my noble friend, Lady Lister. And she and Baroness de Souza have set out, I believe, adequately the reasoning for this amendment. So I will not go into further detail. But, my Lords, I will say this. There is evidence of ongoing torture in Rwanda. That was made plain to us during the committee stage from the intervention of my noble friend, Baroness Whittaker. It's been made plain to us by the briefings that we have received from Redress, amongst others. And I make these criticisms, my Lord, with a deep, deep regret, because I believe the UK government cannot be easily forgiven for the harsh spotlight it has put on a country that has striven to improve since that genocide and continues to improve. And that is why I say with the greatest respect that our concerns are for the most vulnerable, not only who will go there, but will pull upon the resources that are there already for those in need. So therefore, my Lords, I also want to say how much I think the House, if the noble and learned Lord Anderson puts his amendments to the test of the House, I do hope your Lordships will support them. As I've said before, like a cheap curry repeating myself, they are so sensible, and that is probably the reason why the government will encourage us to reject them. Finally, my Lords, this is about supporting, as I said, the most vulnerable. This group of amendments is about supporting those most in need. If we cannot offer support and consideration to those most in need, my Lords, then I have to ask myself, what kind of country have we become, and what principles do we serve, except perhaps naked self-interest?
Lords, I should like to speak to two amendments in the name of the Baroness Meacher and myself, which are Amendments 23 and 27. And they deal with Clause 4, Subclause 1, A and B, and it relates very simply to compelling evidence. If I may say to your lordships, that in order for someone to be found requiring particular individual circumstances, the threshold is quite simply too high. And so the point of these two amendments is to take away the word compelling.
Very good.
About Lord Anderson's amendment number 9, which on the face of it seems extremely reasonable. Whenever, if new clear evidence emerges, new facts emerge, then they should obviously be presented and tackled appropriately. But I wonder whether we're mixing up what the law can do with operational issues. We have, after all, as has been explained at some length from the front bench in the last debate, a monitoring committee with all sorts of bells and whistles which should be able to pick up anything which is going wrong on the ground floor. It's on the ground floor which matter. And it's that issue, operational versus the law, which concerns me. I want to quote to the House the remarks of Sir Robert Neal, who is a lawyer and chairman of the House of Commons Justice Committee, in his comments at the, I think, the third reading of the bill. He said, equally, the idea that legislation is the sole or even the principal solution to this situation is, I think, wrong. Ultimately, an operational solution is required. Ultimately, he goes on, ultimately, it will be operational measures that will make the difference. And I think this is the point. I think there's a danger here of mixing up operational issues, what may be dealt with by governments, by the Rwanda government, by the British government, by the instruments put in place by the treaty on the one hand, and getting the courts involved at too early or an inappropriate stage. I think that is the risk with the commendable idea which Lord Anderson has.
You would expect the Bishop of St Edmundsbury and Ipswich to support Lord Anderson of Ipswich, which I will do, but I want to just say a few words about Amendment 39, which has been tabled in the name of the noble Lord Blunkett, to which I added my name, and the name of my Right Reverend friend, the Bishop of Bristol, also was added. It simply is to ask that the right be given to those who have been who go to Rwanda and granted refugee status to, in some circumstances, to be able to return, because it may well be that Rwanda is not a country where they should remain. You can imagine issues around language, issues around the possibility of destitution, risks to victims of modern slavery, various circumstances, and the not allowing those granted refugee status to return to the UK would seem to be a failure in this bill. It's not unprecedented, indeed. The arrangements currently being made between Albania and Italy mean that those processed in Albania can, if they choose to do so, return to Italy. So I would urge that this amendment be considered as a way of making that option available.
My Lords, can I briefly just rise to say that we very much support the amendments 9 and 12 that Lord Anderson has led on, which would allow the presumption that Rwanda is a safe country to be rebutted by credible evidence presented to decision makers, including courts and tribunals. And if he were to test the opinion of the House, we'd very much support him with respect to that. Can I just refer to my own amendment 29, which I hope gives some evidence to the need for Lord Anderson's own amendments, and that refers to Clause 4, Section 2. My Amendment 29 would take out Section 2, and the reason that I have put that is because I fail to understand why a decision maker, however that is defined, whether it's the Secretary of State, a court or a tribunal. But my lords, in clause 4.2, it goes on to say, to say that subsection 1 does not permit a decision maker to consider any matter, claim or complaints to the extent that it relates to the issue of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its obligations. In other words, an individual cannot put before the court or a tribunal, not that they may be refooled, but using the government's own words in subsection 2, subsection B of clause 4, will be refooled. I mean, I can just about understand it if it just had the word may, but if an individual cannot even argue that they will be, I find that quite astonishing. And therefore, I would suggest that my Amendment 29 highlights why Amendments 9 and 12 in the name of Lord Anderson are very much needed.
My Lords, I thank noble Lords for their contributions to this debate. So turning first to Amendment 39, tabled by the noble Lord, Lord Blunkett. As I set out during committee, we don't consider it necessary to make this amendment. Clause 1 sets out the obligations that the government of Rwanda has committed under the new treaty. The addition proposed by the noble Lord does not reflect the arrangements under the treaty. Enabling persons whose claims are successful in Rwanda to return to the UK would be entirely inconsistent with the terms and objectives of the treaty. Those relocated to Rwanda are not intended to be returned to the UK except in limited circumstances. And Article 9 of the treaty clearly sets out that Rwanda shall process claims for asylum in accordance with the Refugee Convention and this agreement. Since the partnership was announced, UK officials have worked closely with the government of Rwanda to ensure that individuals relocated under the agreement will be safe and that their rights will be protected. Human rights have been a key consideration throughout this work, including the treaty, to confirm the principles for the treatment of all relocated individuals in an internationally binding agreement, and strengthen monitoring mechanisms to ensure practical delivery against the obligations. For example, individuals once relocated will have freedom of movement. They will not be at risk of any risk of destitution, as they will be accommodated and supported for 5 years. They will have access to a generated integration package so they can study, undertake training and work and access healthcare. For those who are not registered as refugees, Rwanda shall consider whether the relocated individual has another humanitarian protection need. Where such a humanitarian protection need exists, Rwanda shall provide treatment consistent with that offered to those recognised as refugees and permission to remain in Rwanda. Such persons shall be afforded equivalent rights and treatment to those recognised as refugees and shall be treated in accordance with international and Rwandan laws. For those relocated individuals not recognised as refugees or granted protection, Article 10 of the treaty provides that Rwanda shall regularise their status in the form of a permanent residence permit and provide equivalent treatment as set out in Part 2 of Annex A. My Lords, it's the government of Rwanda who will be considering asylum or protection claims and who will grant refugee or protection status to those relocated to Rwanda under the treaty, which will underpin the Migration and Economic Development Partnership, not the UK government. As made clear in the agreed terms of the treaty, those relocated will not be returned to the UK except in limited specified circumstances. Obtaining refugee status in Rwanda does not grant that person any rights within the UK, as would be the case for any other person granted refugee status in Rwanda who had not been relocated from the UK. Anyone seeking entry to the UK in future would have to apply through legal routes, such as the work or family route, with no guarantee of acceptance. My Lords, Amendments 9 and 12, moved by the noble Lord Anderson, and Amendment 19, tabled by the noble Baroness Lady Chakrabarti, seek to qualify the requirement for decision makers, including courts and tribunals, to conclusively treat Rwanda as a safe country, thus allowing individuals to challenge removal decisions on the grounds that Rwanda is not a generally safe country. My Lords, the treaty, bill and evidence together demonstrate that Rwanda is safe for relocated individuals and that the government's approach is tough but fair and lawful. The government is clear that we assess Rwanda to be a safe country, and we have published detailed evidence that substantiates this assessment. This is a central feature of the bill, and many of its other provisions are designed to ensure that Parliament's conclusion on the safety of Rwanda is accepted by the domestic courts. The conclusive presumption in the bill that Rwanda is generally a safe country is not, as the Noble Lord suggested, a legal fiction. The courts have not concluded that there is a general risk to the safety of relocated individuals in Rwanda. Rather, the Supreme Court's findings were limited to perceived deficiencies in the Rwandan asylum system and the resulting risk of refoulement should any lack of capacity or expertise lead to cases being wrongly decided. As we have repeatedly set out, the treaty responds to those key findings. The assurances we have since negotiated in our legally binding treaty with Rwanda directly address these findings by making detailed provision for the treatment of relocated individuals in Rwanda, ensuring they will be offered safety and protection with no risk of refoulement. My Lords, we've been clear that the purpose of this legislation is to stop the boats, and to do that we must create a deterrent that shows that if you enter the UK illegally, you will not be able to stay. We cannot allow systematic legal challenges to continue to frustrate and delay removals. It is right, therefore, that the scope for individualised claims remains limited to prevent the merry-go-round of legal challenges and to enable us to remove from the UK individuals who have entered illegally. We cannot allow illegal entrants to be able to thwart their removal when there is a clear process for the consideration of a claim based on a risk of serious and irreversible harm. We cannot allow the kind of spurious legal challenges we have been seeing for far too long to continue. And it's for this reason that I cannot accept Amendments 23 and 27 tabled by the Noble Lady Baroness Meacher, which seek to lower the threshold for a claim or appeal brought on the grounds that Rwanda is unsafe to succeed. These amendments undermine the core principles of the bill, which is to limit challenges brought against the safety of Rwanda. The bill makes it clear that Rwanda is generally safe, and decision makers as well as courts and tribunals must treat it conclusively as such. This reflects the government's confidence in the assurances of the treaty and in Rwanda's commitment and capability to deliver against these obligations. As I've set out, the UK and Government of Rwanda have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. So following on from my previous point with regards to relocated individuals in Rwanda being offered safety and protection with no risk of refoulement, I will now turn to Amendments 11, 14, 15 and 29, tabled by the Noble Lord, Lord Coker. My Lords, I consider these amendments to be unnecessary. As I've just stated, yes, the Supreme Court did find deficiencies in the Rwandan asylum system that meant there was a risk that those relocated under the terms of the previous Memorandum of Understanding with Rwanda could be refooled. However, the UK and Rwanda have since worked closely together to address the Court's conclusions. My Lords, as you are aware, the Supreme Court could only consider evidence up to the summer of 2022, which was not reflective of the current evidential position. Not only could the Court not consider additional work undertaken with the Government of Rwanda to build capacity in the Rwandan asylum system, but they have also not had the opportunity to consider the terms agreed under our new legally binding treaty with Rwanda. The treaty makes very clear that no one relocated to Rwanda will be returned to another country except in very limited circumstances back to the UK. This expressly addresses the Court's conclusions by eliminating the risk of refoulement. As I've said previously, and as I stated in my letter to the Noble Lord Lord Kerr following the debate on this matter at committee stage, the treaty contains, amongst other provisions, a definitive undertaking from the Government of Rwanda that they will not remove any person relocated under the MEDP except to the UK in accordance with Article 11(1).
Very good, Mr. Minister. Can you confirm that the arrangement described in Article 10(3) of the treaty has been devised? That's the arrangement to ensure that refoulement does not in practice occur. The treaty imposes an obligation on both parties to agree a process. Has it been agreed, and can we see it?
I'm afraid I don't know the answer to that question. I will find out, however, and come back to the Noble Lord as to whether it has actually been agreed yet and where we are. There is therefore no need for this, we believe, to be considered. We're making individualised assessments as to the safety of Rwanda. My Lords, the treaty also enhances the role of the Independent Monitoring Committee, which we discussed in the last group. The monitoring committee will provide real-time comprehensive monitoring of the end-to-end relocation and asylum process, ensuring delivery against the terms of the agreement and in line with both countries' international obligations. This will prevent the risk of any harm to relocated individuals, including potential refoulement, before it has a chance to occur. Rwanda is one step closer to ratifying the treaty, as discussed, which has passed through their lower house in Parliament, and once ratified, the treaty will become law in Rwanda. It follows that the government of Rwanda would be required to give effect to the terms of the treaty in accordance with its domestic law, as well as in international law. Those in genuine need of safety and security will be provided with it in Rwanda. Turning to Amendment 16, tabled by the Noble Lady Baroness Lister of Bertaset, we do not accept that the individuals relocated to Rwanda would be at risk of torture or any other form of inhumane or degrading treatment. The government's assessment is that Rwanda is a safe country and respects the rule of law. Rwanda is a signatory to the United Nations Convention Against Torture, the Convention on Refugees, and other core UN human rights conventions. It has also signed the treaty with us, which guarantees the welfare of all those relocated under the partnership. The Enhanced Monitoring Committee will be in place to robustly monitor adherence to these obligations. And should somebody with a particular vulnerability be relocated to Rwanda, there will be the necessary treatment and specialist support available, with safeguarding processes in place. Furthermore, Clause 4 of this bill preserves the ability of individuals to challenge removal due to their particular individual circumstances, if there is compelling evidence that Rwanda is not a safe country for them. That is the appropriate mechanism to ensure that an individual's circumstances have been considered.
Right, but could I ask what investigations the government have made that this support is available in Rwanda? I mean, we've heard about, and this is not a criticism of Rwanda, but it's an acceptance of the facts that it is a country that has poor provision, as we have heard from the Noble Lord, Lord Scriven and others. And in terms of the individual challenge, being able to say that it's not safe for an individual, as his colleague said at committee, the government expect this to be used or be successful very rarely. So that is no safeguard, really.
Well, I was about to answer the Noble Lady's questions, because safeguarding arrangements are set out in detail in the standard operating procedure on identifying and safeguarding vulnerability, which states that at any stage in the refugee status determination and integration process, officials may, of course, encounter and should have due regard to the physical and psychological signs that can indicate a person is vulnerable. The SOP sets out the process for identifying vulnerable persons and, where appropriate, making safeguarding referrals to the relevant protection team. Screening interviews to identify vulnerabilities will be conducted by protection officers who have received the relevant training and are equipped to competently handle safeguarding referrals. The protection team may trigger follow-up assessments and/or treatment as appropriate. In addition, protection officers may support an individual to engage in the asylum process and advise relevant officials of any support needs or adjustments to enable the individual to engage with the process. Where appropriate, the protection team may refer vulnerable individuals for external support, which may include medical and/or psychosocial support or support with their accommodation, and where possible, this should be with the informed consent of the individual. My Lords, as regards capacity, of course the capacity will be in place, and the policy statement sets out, I think at paragraph 135, that in line with our obligations under the Refugee Convention and to ensure compliance with international human rights standards, each relocated individual will have access to quality, preventative and curative primary and secondary healthcare services that are at least of the standard available to Rwandan nationals. This is provided through a comprehensive agreement between the government of Rwanda and medical insurance companies for the duration of 5 years and through MOUs with hospitals in Kigali. Can I also say, though, at this point, that it would be far in the best interests, the mental health interests of those seeking asylum and who are victims, to seek asylum in the first safe country they came to. Why would they risk their health and mental health crossing the channel in much more grave circumstances than they need to? My Lords, Noble Lords will know that over 135,000 refugees and asylum seekers have already successfully found safety in Rwanda. International organisations, including the UNHCR, chose Rwanda to host these individuals. My Lords, we are committed to delivering this partnership. With the treaty and published evidence pack, we are satisfied that Rwanda can be deemed a safe country through this legislation. So I would ask the noble Lord to withdraw his amendment.
May I thank all noble lords who have participated in this fast-paced debate and for the generous and constructive contributions that we've heard from all corners of this House. I shan't dwell on them individually, but may I single out the contributions we heard from the Noble Baroness Lister, Noble Baroness de Souza and Noble Lord Cashman on the subject of torture. And although my amendments are broader than theirs serve as a reminder that even evidence of widespread torture would be off limits if Clause 2 were not amended as they and I both wish. I say to Lord Murray, Noble Lord Murray, that I'm delighted by what he says he has seen in Rwanda, but with great respect to him, the points he makes in no way remove the desirability of ensuring that should protections not prove to be adequate, including, for example, protections against the risk of refoulement contrary to the terms of an agreement, which is what we saw when the Rwanda-Israel agreement was in force, then the decision makers and courts should be able to take those matters into account. That is all that these amendments contend for. To the Noble Lord Horam, I agree that it is operational measures that will make the difference. He must be right about that. Those are the sorts of measures that were identified by the International Agreements Committee in its list of 9 or 10, and indeed in Article 10.3 of the treaty, as the Noble Lord Kerr pointed out, unfinished business even when the treaty is ratified. The purpose of the courts is simply as a check that those measures meet the minimum thresholds laid down by law. The Noble Lord the Minister made the point that the concerns expressed by the Supreme Court were limited to specific issues regarding refoulement, and he suggested that those issues, if they hadn't been resolved already, would be easily resolved in the near future. I must say that the Noble Lord does ask us to take a good deal on trust. I understand that a letter has been circulated this afternoon, certainly didn't reach me, but whether that includes, for example, full details of the Rwanda Asylum Bill that nobody seemed to have seen when we debated this in committee, whether it contains full details of the arrangements to ensure non-refoulement that are referred to in Article 10.3 of the treaty, I cannot say. Yes.
The letter came to myself. Can I just say, in answer to his questions, the answer is no.
Well, I'm grateful, and I should say, in fairness to the Minister, that I had a letter about Northern Ireland, but it didn't touch on those issues. But I acknowledge the confidence with which the Minister defended the position on the ground in Rwanda, and I would say all the more reason then to accept these amendments. The more confident the government is in the safety of Rwanda, the less it has to fear from them. So for those reasons, I am minded to test the opinion of the House on my amendments in this group.
The question is, excuse me, the question is that Amendment 9 be agreed to. As many as are of that opinion will say content.
Content.
The contrary, not content. Not content. I'll call again. As many as that opinion will say content. Content. The contrary, not content. Not content. The question will be decided by division. I will advise the House when voting is open. Voting is now open. Clear the bar. order. The question is that Amendment 9 be agreed to. As many as of that opinion will say content. Content. The contrary not content. Not content. The contents will go to the right by the throne. The not contents to the left by the bar. that Amendment 9 be agreed to? There have voted contents 258, not contents 171. The contents have it. My Lords, I cannot call Amendments 10 and 11 due to preemption, and I would like to remind the House to peers should not cross the floor in between the woolsack and the clerks during voting. Thank you. We now come to Amendment 12, and if agreed, I cannot call Amendments 13 to 16 due to preemption. Amendment 12.
The House.
The question is that Amendment 12 be agreed to. As many as that opinion will say content. Content. The contrary not content. Not content. The question will be decided by a division. I will advise the House when voting is open. Voting is now open. Clear the bar.
The question is that Amendment 12 be agreed to. As many as are of that opinion will say content. Content. Contrary, not content. Not content. The contents will go to the right by the throne, the not contents to the left by the bar. The question is that Amendment 12 be agreed to. My Lords, there have voted contents 260, not contents 169. So the contents have it. My Lords, I am unable to call amendments 13, 14, 15 or 16 for reason of preemption. So I call Baroness Lawler to move Amendment 16.
My Lords. Sorry.
Amendment 17.
My Lords, I support the aims of this bill and I hope it and they will succeed, that it will not be challenged, that there will be no further obstacles put in the way of removing people who come to this country illegally and by these dangerous routes. My Amendment 17 is to Clause 2, to leave out subsection 5 and substitute the text on the marshalled list. The aim is to tighten the bill and prevent or delay the removal of an individual to Rwanda under any of the Immigration Acts, the Human Rights Act 1998, EU-derived law and case law, Sections 2 to 7 of the European Union Withdrawal Act 2018, and any provision of domestic law, including common law and international law, relevant to the aim, so to limit legal challenges to the bill. I do not share the views of those who say the bill contravenes the rule of law. Their view rests on assumptions about the role of international law and its place within our own system, and the creative approach of the Strasbourg Court in applying the Convention, and on the tendency now to accord something of a primacy to courts over Parliament. These assumptions are contested within the legal profession itself. I'd like to refer to one KC, Anthony Spate, whose paper was published at the weekend by Politaire, of which I am research director, and I therefore declare a special interest in the matter. Spate explains the comparative novelty of such a view, which he dates from Lord Bingham's 2010 book, that the rule of law requires adherence to international law. But I am not a lawyer. I approach the question as a historian of British political and constitutional history. It is a history, by and large, and certainly in the era since the franchise was extended in the 19th century, of the interplay between executive and parliament, with government accountable through parliament to the will of the people, even before the extension of the franchise. At the moment, both government and parliament are intent on being accountable on this matter of curbing illegal immigration, but are prevented by laws and the judiciary which operates them, or, as in the case of the Strasbourg Court, interprets them in a manner which takes from and not protects their liberty, on which good law is based, the freely expressed will of the people who are governed. On immigration, legal and illegal, the people have spoken loud and clear. They want Britain's borders controlled and the flow of immigration curbed. Parliament has passed the laws to bring such control, but each bill it brings forward meets a challenge in the courts. Is removal to Rwanda to be stopped, not by recalcitrant authoritarian monarch or an oligarchic aristocratic landowning parliament, as in the past, but by a judiciary acting, I do not doubt, in good faith, to give effect to a cocktail of legislation binding this country from an era whose laws are not our own and from times that are not our own. There are practical limits to what a government, good government, can achieve. It is recognized perhaps more clearly by voters than by rulers that uncontrolled immigration, facilitated by the obstacles now put by the courts, often, as in the case of illegal immigration, through asylum claims, has consequences for the economy in terms of the budgetary costs and puts demands which can't be satisfied on Britain's domestic arrangements, not just for processing claims, but every manner of support which the UK's people have over the centuries shown to those who, for whatever reason, come to make their lives in this country. If our constitution is to survive the onslaught of legal challenge, the will of Parliament, reflecting the mandate of the voters, must triumph, and with it the stability, transparency and accountability which has brought to Britain and its people, rather than be challenged on account of international or our own laws. This country is no outlier, my lords. Across the Channel, the political systems of Western European neighbours are buckling under the political immediacy of uncontrolled immigration, each seeking to exploit or avoid the system to which in law they are bound under EU law, convention law, and the mass of internal legislation to which these have given rise. they also have Schengen to take account of. Take the case of France. Its political system was practically frozen for 2 years, haggling over an immigration bill, which many see as promising too little, too late. The problem with which it too grapples are immense, the constitutional arrangements and stability under threat at different levels, departments pitted against national powers, as in the recent standoff between some mayors who refuse to accept unaccompanied minors because they have no ability to do so and look after them. At government level, against the ruling of the Strasbourg court, its voters against the traditional systems of the political parties, the Republicans and the Socialists. We in this country are free to make our own laws. And other noble lords in this group will speak on their amendments to this, the amendments they intend to move on the same theme. My amendment aims to tighten the bill, to preempt further challenge, which, as the Minister mentioned earlier, is a core principle and aim of this bill, to prevent further challenge, and to the workings of ordered and representative and accountable democracy, and to promote the aims of the bill to delay illegal and unsafe crossings and deter the horrid loss of life, such as the death of a little girl of 7 in the Channel on Sunday night in freezing waters. I therefore beg to move.
Amendment proposed, page 3, line 13. In place of the words last left out, insert the words as printed on the marshalled list. Amendment 17.
My Lord, I rise to speak also in favour of Amendment 17, tabled by my noble friend Baroness Lawler, to which I've added my name. As I said at second reading, I do support the bill. I am a bit afraid the Rwanda policy is a bit of a Heath Robinson arrangement and does shy away from some of the tough decisions really needed to solve the problems. But still, I support the bill because it's the plan we have, and we must hope it makes a difference. But it can certainly be improved. Now, most of the amendments we've discussed today would make it worse rather than better, less effective rather than more effective. Amendment 17 is one of the few exceptions to that, and it aims to provide a more clearly drawn bill, one that can withstand challenges and fulfil its purpose more effectively by making clear that no other legal provisions of any kind, whether in domestic or international law, can be used to frustrate the policy. Now, my Lords, I don't want to repeat issues that have already been raised in committee and discussed again at length today, but I do want to briefly explain why I support this amendment and then to make one comment at the end based on my own involvement in recent years on this issue of the intersection between international and domestic law. So, first of all, it's in my view absolutely clear that this Parliament may legislate against international law, and indeed the government may act in contravention of international law. As we've already heard, Clause 1, Paragraph 4 makes that clear, and nobody is seeking to amend that. It is a long-standing fundamental element of our Constitution. Now, it's not some sort of weird UK-specific provision. There's a good reason for this dualism in our system. First of all, is that otherwise governments could act to create domestic law merely by signing an international treaty and thereby sidestep normal democratic processes. Second, it reflects the reality that international treaties are in practice very difficult to adapt to changing conditions because all the parties must agree to changes. Now, it's been suggested by some noble lords today and in previous debates that that's what should happen, that we should seek to renegotiate the international framework. Now, the Refugee Convention, for example, has got 149 state parties at the moment, including such well-known supporters of international law as China, Russia, and Iran. Are we going to wait for all of them to agree to amend this framework? Now, we're clearly not. But if national governments accept they can only act, they can only deal with pressing national challenges by renegotiating these treaties, then they're effectively abandoning their duty to govern their own countries on matters of huge importance. Now, if a government chooses to act against international law, it may pay a reputational price for it, a price that, as we've heard in the case of France, is often hugely exaggerated. It may consider that price justified, depending on the circumstances, but it must weigh up that price. Now, that's what the government's done in this case. I do worry it set the balance in the wrong place. It set supposed compliance with international obligations crafted in a different era. It set that onto a higher plane than the core state function, one of the basic raison d'etre of a government, which is to control the country's borders. And that's where Amendment 17 is designed to help. It's designed to deliver the goods which are invoiced, as it were, in Clause 1, Paragraph 4. That clause recognises there is a right for governments to act, and Amendment 17, if it were to be agreed to, which I suspect it isn't going to be, but if it were to be agreed to, it would be the necessary action. It does what's necessary to make this policy work by closing off, as far as possible, the ability to challenge it and the ability of domestic or foreign courts to act against it. And it does that with the goal of delivering what people in this country want, a government that's actually in control of our borders. Now, just briefly to finish my second point in my comment, I know this is the third time Parliament has debated this issue of compliance with international law, and I've had some small hand in two of the previous occasions. The UK Internal Market Bill, now Act, where the relevant clauses that would have explicitly breached international law were withdrawn. Then the Northern Ireland Protocol Bill, where the whole bill has been withdrawn. And now we have the Rwanda policy. Now, it's not a coincidence that this keeps coming up. The UK is enmeshed in a set of international legal obligations, which in defiance of our constitutional traditions are in practice constraining the sovereignty of this Parliament, and therefore the ability of any government to act in the interests of the good governments of this country. Now, while we were in the EU, the huge constraints that all this imposed, membership of the EU imposed, made those other legal obligations less visible, though no less intrusive. Now, we're not in the EU, they're there for everybody to see. So, mark my words, I'm afraid, this issue is not going to go away. I don't think the government's quite faced up to it with this bill. It in particular hasn't faced up to what I think is the need to free ourselves from the ECHR. And I think the only issue is how much more time is going to be wasted, how many more constitutional traditions are we going to lose, how much more is democracy going to be circumscribed before government does what's really necessary in making the top priority the democratic wishes of our citizens and the good governance of this country. And that's why I support to complete Amendment 17. It at least shows the necessary direction of travel, and it signals very clearly what, in my view, is in the end going to be necessary to fix this problem.
My Lords, just very briefly, I wanted to support Amendment 17 in the name of Baroness Lawler, and to just say a few words about the Northern Ireland perspective on this, because we've had this discussed at various stages about whether this is really going to apply to Northern Ireland and the effects if it doesn't. Now, in the amendment itself, of course, even in the Safeguarding the Union Command paper, there are a number of things that have already been exposed as not actually correct. And on the amendment, I would have actually liked more specific language in subsection 5C, so that there could be actually specific mention when we talk about international international law, to actually mention section 7A of the European Union Withdrawal Act. because I think sooner or later, and I think the Noble Lord Frost is absolutely right, this is not going to go away, and sooner or later we're going to have a legal challenge, probably first in Northern Ireland, on Section 7A and how this is, whether this applies. Because we saw last week the effect of the protocol framework is to give EU law supremacy in Northern Ireland, even to the point whereby the Act of Parliament that was passed, whether you agreed with it or not, the legacy bill, could be struck down due to inconsistency with EU law applying because of the protocol. And I think the government and the minister does need to actually clarify, because there is a lot of confusion and a lot of, let's say, being gentle, misleading about this how Article 2 actually works. Now, Lord Kane, the Noble Lord Kane, in written answer to me on the Rwanda Bill, claimed that the EU Charter of Fundamental Rights did not apply to Northern Ireland via Article 2 of the Protocol Framework. And this is actually at variance directly with the High Court judgment in Angesom, and also, of course, the last week's High Court in Northern Ireland disapplying 10 provisions of the Legacy Act. So the government can't really keep making claims that are so obviously not true, and then get really angry almost when we point out things legally as to how it's working. So I think this is another example of the degree by which control over part of the United Kingdom has been really genuinely surrendered by this government while pretending that it's not happening. Let's not forget that the Windsor Framework, it's very specific. Page 19, paragraph 46, that the Windsor Framework only applied in respect of trade, and that Article 2 did not apply to immigration issues. I think we're going to find that that is not correct. So on this issue of the Rwanda Bill and the effect of Article 2 of the Protocol Framework, the proponents of the deal really need to be clear. It doesn't apply in this bill in the same way in Northern Ireland, because of Article 2 prevents it doing so. The EU Charter of Fundamental Rights continues in Northern Ireland, and I think we should be honest about that. And the Protocol Framework provision trumps domestic law and trumps the wishes of our sovereign Parliament. And I think noble lords should be aware that we are going to find that whatever your views on this Rwanda Bill are, that ultimately this is going to end up in another legal challenge, which will, whether the bill has gone through or not, will delay its implementation. So I do support the amendment, even if it didn't specifically mention the withdrawal agreement.
I'd like to speak to Amendment 18, to Amendment 20, which I share with the Noble Viscount Hailsham, with the Noble and Learned Lady Baroness Hale of Richmond, and the Lord Archbishop of St Edmundsbury and Ipswich. And I also support the Starred Amendment 21 in the name of Lord Jermyn. Amendments 20 and 21 both restore Human Rights Act protection in full for those subject to this bill and pending removal to Rwanda. I think that the Noble Lord Jermyn's amendment does it in even clearer language by not referring internally to last year's bus or last year's immigration bill, but clearly stating for the lay reader that Human Rights Act protection is restored. The Amendment 18 is, however, a revision of the amendment tabled last time at committee by the Noble Lord Kirkup. It's a modest revision in order to address some of the concerns made by some of his noble friends. He's not able to be here this evening. And I begin with that one because it really is so mild and so in keeping with the thrust of the bill, and cannot be described as wrecking or disturbing the framework, even of a bill I object to, in any way. All it would do, Noble Lords will know that in clause 3 of the bill, most Human Rights Act protection is removed for these vulnerable people. But the one thing that is left is the possibility of a declaration of incompatibility. And contrary, I fear, to some of the comments made by the Noble Lord Clerk of Nottingham and others, there is no possibility in our arrangements for a strike down by the Supreme Court of this bill were it to become an act, because that is not the arrangement that we have in the elegant British constitutional compromise of the Human Rights Act and the balance it strikes between the rule of law, that is the bedrock of any democracy, and parliamentary sovereignty. So if an act is declared incompatible, that declaration has merely moral and persuasive effect, and the act continues in operation. That's why, with the greatest of respect to him, the Noble Lord Clerk was optimistic to the point of being wrong about that. And so what the Noble Lord Kirkhope came up with last time was just a suggestion that if there were to be a declaration of incompatibility made by our higher courts in relation to this legislation, there should be accelerated consideration in Parliament. That's it. And I'm pretty flabbergasted with the government's response that they wouldn't even have a look at that most modest amendment by their noble friend, a former immigration minister, Lord Kirkhope of Harrogate. And so in his absence, I've retabled it. It's been tweaked slightly to address some of the points made by his noble friends last time, and I really do look forward to hearing what the objection is to that modest suggestion that he made, that if there is a declaration, Parliament should have an accelerated timetable, and ministers should put their arguments to Parliament, not to a court, but to Parliament, and Parliament be given the opportunity to consider what to do next. As for our amendments to restore Human Rights Act protection and restore, again, it's another way of trying to restore the protection of the domestic courts. I just say to the government, and here actually Lord Frost has a point, where the government have left us with this bill is probably, if it passes unamended, we will be in a situation where the only court that will really be seized of these matters, the only court that will be able to have full jurisdiction over the safety of Rwanda and over individual removals from this country to that country, will be the European Court of Human Rights. Of course, interim measures will be ignorable by a Minister of State, but final orders of the European Court will still be an international legal law obligation, and that has not been removed by this bill. Therefore, Lord Frost is actually the one who's telling the truth about the logic of where this government is heading. And that is really for walking out of the Court of Human Rights, walking out of the Council of Europe. We can follow Russia and be the next ones out. At least he is honest about that position, whereas the government is trying to have it both ways. And what they've done is they've defenestrated domestic courts, gaslit the Supreme Court, but the only court that will be left for redress in any real terms will be the Strasbourg court. And then, of course, the Prime Minister can say, I told you what I said about foreign courts, because foreign courts will be all that is left, if that is what we now say about international courts. Goodness me, what terrible, terrible politics. And finally, I say to the noble Lord Frost, who sort of had enough of international law, really, because, you know, that's kind of where he's coming from. The challenges facing not just the United Kingdom, but the world today, the most pressing challenges, whether climate change, war and peace, the challenge of the ungoverned continent that is the internet, AI, robotics. How on earth are we going to address these challenges of the 21st century in a unilateral way? It is just nonsense. And to the noble Lady Lawler, who doesn't seem to like law, whether it's domestic or international, I hope she never has need of it. I hope that she is never subject to the kind of abuse of power that sometimes people are subject to, and they need the protection of the courts.
Sits down. May I ask her to be clear about what I proposed and to what I was referring. I was referring to the laws of this country made by the people of this country with the support of the people of this country. Good laws. Yes, they support international treaty law when that is in the interests of this country and other wider interests which arise, whether it's trade treaties or international agreements over other matters. But it is wrong to suggest I am not in favour of law. I am in favour of good law, but not politicised law, as it very often is by the interpretations of the Strasbourg Court, of the Convention.
Well, I'm very grateful to the noble lady for her clarification, though of course, as I pointed out, and I think Lord Frost was nodding, the Strasbourg Court is unaffected in its final jurisdiction by this bill. It is our domestic courts who are defenestrated by this government policy, and I just look to her amendment, which is actually abrogating domestic laws, any provision by the Immigration Act, the Human Rights Act, another domestic statute, any other provision or rule of domestic law, including any common law, in case Magna Carta still got a shout out there, and of course international law. So she's been pretty comprehensive in her approach to law in this amendment, whether domestic or international. Of course, she says, but these are just it's only bad law that I don't like. But of course, we all have our own views, don't we, about good and bad law. But some of us believe that there should be referees in a democracy that is built on the rule of law. And the rule of law was invoked, as I said earlier, by the Prime Minister, even in his slightly odd Downing Street declaration on Friday.
He sits down. May I clarify that my amendment is designed to promote the aims of this bill, to remove people who come to this country illegally to Rwanda and to stop obstructions on this matter.
My Lord, could I add a very, very few words to this debate on the Human Rights Act? And I would like to point out that this is the first time that I've actually spoken in this group. This amendment seeks to return the responsibility of interpreting the law to the courts, and specifically underlines the unacceptability of a law on the statute book which is incompatible with domestic law, which of course includes the UK Human Rights Act. And unless and until the courts affirm that the Act conforms with the strictures of the Human Rights Act, it must not have any effect. To do otherwise, my lords, would be to reject the rule of law, which is one of the pillars of the UK Constitution.
Well, I just want to speak a couple of brief points in support, in particular, of Amendments 20 and 21. First, in committee, the noble and learned Lord, the Minister, Lord Stewart, quoted at length the Lord Chancellor's submission to the Joint Committee for Human Rights to justify breaching the universality of human rights. Now, clearly, the Lord Chancellor didn't convince the Joint Committee on Human Rights, which in its majority report concluded that the provision threatens the fundamental principle that human rights are universal and should be protected for everyone. So why, I still don't understand, given the concerns expressed by the JCHR and also by, for example, the EHRC, the Law Society, the Northern Ireland Human Rights Commission, does this government continue to try to argue that disapplication does not affect the principle of universality, which in fact the noble learned Lord waxed lyrical about in his speech? Second, the noble and learned Lord promised to write to me in response to my concerns about the implications for the Windsor Framework and the Good Friday Agreement, and following on from the noble Baroness Lady Hoey, and the Joint Committee for Human Rights request for a full explanation before report stage as to why the government considers Clause 3 is consistent with these agreements. Well, I thank the noble and learned Lord for his letter, but echoing what the noble Lord German said earlier, I would gently point out that it was sent at 3:24 this afternoon after report stage began. That really is not good practice. And it does not meet the JCHR's request that the explanation, a full explanation, should be published before report stage. And it seems that the actual full sort of publication won't be until sometime by Wednesday, when we'll be finishing report stage. Now, I'm not convinced about the answers to my question that they would satisfy the JCHR, the Northern Ireland Human Rights Commission, or the Human Rights Consortium of Northern Ireland. And I'm also not clear why the letter wasn't copied to the Noble Baroness Lady alone, given that she originally challenged the Noble Lord the Minister on this point at second reading. But I'm not going to kind of pursue the matter here, but it's just really to point out that I don't think we yet have a satisfactory explanation as to the interaction with these agreements, the implications for these agreements.
My Lords, I'd like to speak to Amendment 21, which is my name, and also to link that with the Amendment 20 and 18. If Amendment 20 had any space, I would have signed it as well, because it makes the same case. I will address the Amendment 17 later, and I'm looking forward very much to seeing how the government deals with Amendment 17 in its response. But at the moment, just to repeat what the universality issue of human rights. It is human rights are for all. I read once again Lord Stewart's, Stilton's, the Noble Learned Lord's response about legitimacy, and I'm sure we'll hear it again today. But there's still the underpinning of the Human Rights Act is that the protections should not be disapplied just to some people. Because if human rights are for all, then if they become qualified, then they are no longer human rights, but only the rights for some people. And this violates the principle of universality of human rights, which is why this amendment is in place. It doesn't matter that this is directed at illegal migrants. Once the government does this for one group, it will choose to use it, or could choose to use it, from other groups, such as protesters. Yes, a protester.
So is the logic of the Noble Lord's point, therefore, that the government would be better to repeal the Human Rights Act completely and revert to the pre-1998 situation?
Simply keep the Human Rights Act, and of course that does do the job that we are we're seeking here. But naturally, of course, if the government wants to move and create a special group, as it is here, what they call illegal migrants, then what about the other groups who might follow from it? Protesters it is very clear that may well be an issue. What groups which are not in vogue with the government? It's a very, very dangerous precedent, and this is a warning sign. Fundamentally, what I think we're seeing here is chasing short-term headlines which will have a significant consequence for people's rights in this country. But, my Lords, not content with arguments the government is having with the views of the ECHR and the UNHCR, the government, just this week, in the last 7 days, has now drawn swords with the United Nations, its Council for Human Rights. Published last Friday, this is what they said: prohibiting courts and tribunals in the UK from applying and interpreting principles of domestic human rights law and international law would undermine the ability of the courts to protect all those under UK jurisdiction from violations of their human rights as provided under international law. And they go on further to say that the government should look at this matter again, and the United Nations have offered to speak and to work with the UK government on this matter. So I wonder if the Noble Lord, when responding, could tell us whether or not they have read the United Nations
Human Rights Council's review, and whether they are prepared to meet with them and to discuss this matter further. But there is also a logical inconsistency, I think, here in what the government's doing. The government can't have it both ways. It wants to rely on the International Convention and jurisprudence in justifying the disapplication of the Human Rights Act, but it's then seeking to disapply the findings of that same court in relation to the same international convention with respect to the consideration of interim orders. So you can't have it both ways, and I think the government needs to be clear on that matter. I just want to make, I think all the comments that the Noble Baroness Chakrabarty has made about Amendment 17 are absolutely accurate. But there is one thing that worries me completely, and that is the part of the amendment which just basically takes away every law that this country might apply in this direction, domestic law and common law of all, for goodness sake, common law as interpreted by the courts. Can you, which I don't know how you find which parts of common law you want to disapply. You have to be specific in what you say if you want to disapply anything of this nature. But basically, what that Amendment 17 looks to me like is a complete wiping out, blanking out, blindfolding every single possible piece of legislation which might stand in the way of this government's view. And that certainly, but absolutely, must affect the balance which we talk about the rule of law in this country. So I look forward to seeing how the government will deal with that amendment, but I would suggest that they might need to consider how they actually move forward and no further discipline application of the Human Rights Act.
My Lords, I'm going to speak quite briefly. These amendments, again, in this group, again demonstrate the threat to the domestic rule of law posed by this bill. This isn't the first bill that threatens the Human Rights Act in this way, but the fact that it now seems almost commonplace for the government to strip back human rights legislation, it does not mean that it should go without objection each and every time. There is much to object to in this bill, and Clause 4 is no exception to that. Each cut to the Human Rights Act matters, and each piece of domestic law that is cut away in search of a quick political gain matters as well. And I hope the government listened to these arguments, the arguments put forward by my noble friends, and see sense. But my Lords, I have to say I found this debate, although relatively brief, actually quite refreshing as well. Because, I mean, Lord Frost was perfectly candid with the House, and it was for a layman, it was much easier to understand the political differences between the view articulated by the noble Lord and the view on the other side of the House, and it was much easier to understand that difference than when I try and decipher the words of the ministers when they respond to these amendments. But nevertheless, I look forward to what the noble Lord the Minister has to say.
My Lords, the noble Lord Lord Ponsonby has flung down the gauntlet. On behalf of His Majesty's Government, I'm happy to pick it up. My Lords, I'm grateful to all who participated in this debate, and I do sincerely echo the words of the noble Lord when he said that it was a refreshing quality to this short debate. I think that the House articulated some important points, and contrasting positions were well properly and clearly laid out for consideration of the House. My noble friend Baroness Lawler opened with the support of my noble friend Lord Frost, and I begin by saying, as I've said at an earlier stage in this debate, or rather in the handling of this bill, that it is important to recognise, as my noble friend did, that the levels of illegal migration to this country, perhaps to the whole of Western Europe and other comparatively prosperous parts of the world, are placing enormous strain, not only on us economically, but also straining the fabric of society, and straining perhaps also public confidence in the ability of our courts, and our democratic legislatures to address problems. I'm grateful to both my noble friends for their broad support for the aims and objectives of the bill. My Lords, I think that Lord Frost put it clearly and accurately in constitutional terms when he repeated that this Parliament may legislate in contravention of international law. It is a long-standing element of our Constitution. And the noble Lord also, I think, accurately and correctly identified that the price of any such, the high price to be paid for any such step, is a matter of reputation. That such reputations of countries as of people may be very easily lost. I echo again what the noble Lord had to say about the way in which it is difficult to adapt international treaties drawn up in different times and in different circumstances. There was an intervention as he was speaking with the noble lady Baroness Chakrabarti, and I think that from the perspective that I took on it, it seemed to me that my noble friend Lord Frost wasn't saying that he'd had enough of international law, but rather that he wished law to operate in its proper context. The noble lady Baroness Hoey made if I may say, an extremely important contribution on what is a very important point, and the noble lady Baroness Lister of Burterset also touched upon that, and it's the status of law of the United Kingdom in one of its constituent parts as opposed to other constituent parts. My Lords, the government is considering the judgment in the case to which the noble lady referred, that of Dillon, in relation to Article 2 of the Windsor Framework, and all the available options, including appeal against that decision, very carefully. Our position is this, that the bill will apply in full in Northern Ireland, and the government is clear that nothing in the Windsor Framework, including Article 2, or the Trade and Cooperation Agreement, affects the bill's proper operation on a UK-wide basis, a matter very important to this government. The government has always been consistent about the position of Article 2 of the Windsor Framework. For Article 2 to be engaged, it would be necessary to provide evidence that the alleged diminution of rights relates to a right set out in the relevant rights, safeguards and equality of opportunity chapter of the Belfast Good Friday Agreement, concerns a right that was given effect in domestic law in Northern Ireland on or before the 31st of December 2020, and occurred as a result of the United Kingdom's withdrawal from the European Union. Nothing, my Lords, in the bill, which is about matters of asylum and immigration, engages any of these issues. As such, it would be incorrect to claim that its provisions are within the scope of Article 2 of the Windsor Framework. The noble lady Baroness Lister of Burterset, in taking up the points, also, I think, perhaps referred to an important matter, which is the speed of communication with letters being written after the earlier stage. I see the noble Lord Cashman nodding his head. I do apologise to the noble lady and to others in the House who are recipients of letters. I signed the terms of the letter off, however inadequate the noble lady may have found it ultimately, but I signed the terms of the letters off on Saturday afternoon. My Lords, if I may continue to take your Lordships through the government's position in relation to the amendment tabled by my noble friend Baroness Lola with the support of the noble Lord Frost. This amendment limits legal challenges. It may be, of one view, seen as undermining the safeguards that are necessary to ensure that this bill and the Illegal Migration Act are compatible with the United Kingdom's international obligations. The Illegal Migration Act and this bill include provision for a person subject to removal to a safe third country to make a limited class of suspensive claim on the ground that they would face a real risk of serious and irreversible harm if they were removed. The threshold for serious and irreversible harm is a high one, and the harm in question must be both imminent and permanent. And, my Lords, this reflects the test applied by the European Court of Human Rights. This legislation provides that a court may grant interim relief only which prevents removal to Rwanda where it is satisfied that a real, imminent and foreseeable risk of serious and irreversible harm is in existence. These measures, my Lords, are necessary to ensure compatibility with the European Convention on Human Rights and ensure that the grounds by which people can challenge removal are appropriately narrow. As has been set out by me and by my noble friend Lord Sharp of Epsom from the dispatch box, and in relation to other amendments, I'll come back to this, the bill reduces unnecessary challenges whilst preserving the principle of access to the courts, where an individual may be at a real risk of serious and irreversible harm. As a whole, the limited availability of domestic remedies maintains the constitutional balance between Parliament's authority and the powers of our courts to hold the government to account. My Lords, this country has a strong track record of rights, liberties, protection of human rights internationally, and we are committed to enhancing that record. Some of the provisions in this bill are novel, though they are not without precedent. Noble Lords will also know that Australia has undertaken a similar approach with Nauru. And we know, my Lords, that other countries are exploring similar models. For example, Italy, which has announced a partnership with Albania. The government, my Lords, is satisfied that the bill can be implemented in line with the Convention rights, and I would ask the noble Baroness to withdraw her amendment. My Lords, the theme of these provisions, the theme of the bill, is very much one, and I echo again the words of my noble friend Lord Howard of Lympney, no longer in his place. It is one of accountability, and it addresses, I think, the concerns that my noble friends from this side advanced to the House, that the effect of illegal migration on the scale with which we are currently experiencing it, and notwithstanding the successes which we have recorded and which I spoke about in an earlier group, are straining not only our ability to fund the phenomenon of illegal migration, but are straining the ability of the electorate to have faith not only in the courts, but in this place. My Lords, in removing Clause 3 entirely, as well as disapplying Section 1.5 of the Illegal Migration Act, as Amendments 20 and 21 seek to do, that would mean that the Human Rights Act applies in full to this legislation, as well as the Illegal Migration Act, in relation to removals to Rwanda. This would increase the risk that a person challenging their individual removal would frustrate the entire scheme by bringing systemic challenges on human rights grounds. It would also increase the risk of litigation, asking the courts to interpret the bill in such a way as to be inconsistent with the clear intent of Parliament, undermining Parliament's conclusion on the safety of Rwanda being accepted by the domestic courts. Section 3 of the Human Rights Act requires courts to interpret the meaning of legislation to make it compatible with Convention rights so far as it is possible to do. Disapplying Section 3 confirms and ensures that the provisions will be interpreted in accordance with the usual principles of interpretation, primarily by applying the ordinary meaning of the provisions. It follows the approach taken in the Illegal Migration Act, which the amendment by the noble Lady Baroness Chakrabarti also seeks to disapply. Disapplying Section 2 of the Human Rights Act ensures that considerations about the Rwanda Treaty and the safety of Rwanda are firmly located with Parliament, providing that element of accountability which my noble friend Lord Howard of Lympney called for so eloquently. Taken together with the rest of Clause 3 and the bill as a whole, this provision makes clear that appropriate deference should be given to Parliament's sovereign and final determination in the matter. Clause 3 also applies, disapplies Sections 6 to 9 of the Human Rights Act from decisions, whether by decision makers or the courts, related to the conclusive presumption that Rwanda is safe and any application of the serious and irreversible harm test. Disapplying Section 6 confirms that public authorities are not bound in domestic law to act in a particular way as a consequence of convention rights. In the context of this bill, which deems Rwanda a safe country, this is targeted at preventing people from frustrating removal by bringing systemic challenges in our domestic courts. The disapplication of sections 7 to 9 of the Human Rights Act follows from the disapplication of section 6. These are the operative provisions of the Human Rights Act that flow from section 6, providing for judicial processes and remedies. Given that section 6 is disapplied, these provisions are not needed. Turning to Amendment 47, tabled by the Noble Baroness Lady de Souza, and Amendment 18, tabled by the Noble Baroness Lady Chakrabarti, these amendments are designed to expand the current process under Section 4 of the Human Rights Act and to place pressure on the government to present legislative proposals to Parliament. In so doing, they seek to oblige the government to respond to declarations of incompatibility in a certain way. And that, my lords, is expressly what... I'll give way to the Noble Lady.
I think a closer reading of the Amendment 18 will demonstrate that it's not ensuring that the government responds in a certain way. It can respond favourably or negatively to the declaration. It just needs to come to Parliament and have the debate.
In her address today, and I think at an earlier stage, has described the functioning of declarations of incompatibility in Section 4 of the Human Rights Act 1998 as an elegant compromise. It is an elegant, I freely agree, constitutional compromise which ultimately reflects that parliamentary sovereignty which lies at the very heart of our processes and our constitution. As detailed during the committee stage, Section 4 of the Human Rights Act, in relation to the system of declarations of incompatibility, is designed to strike that compromise appropriately between scrutiny of human rights and parliamentary sovereignty. Section 4 does not oblige the government to take any specific action as a result of a declaration of incompatibility, and Section 4.6 expressly does not allow a judicial ruling to prevent the operation and enforcement of legislation passed by Parliament. The operation of the section is to afford the government the opportunity to reflect on matters, to listen to concerns brought by the courts, and to act upon them as it sees fit. I do not consider it necessary to adopt the amendment which the Noble Lady has tabled and argued for, but I do so purely on this basis that the history of the application of this section, in my view, respectfully shows it to be working. The Noble Lady Baroness de Souza tables Amendment 47, seeking to undermine Section 4.6 of the Act by providing that a declaration of incompatibility results automatically in the legislation ceasing to have effect. It seeks to give such declarations a binding character, and that, as I was saying a moment ago in relation to the Noble Lady's point, is contrary to what those provisions were designed to be, and removes discretion or oversight, as is currently afforded to government and Parliament, as to what action would be the most appropriate to take in the circumstances. It has been the accepted practice since the introduction of the Human Rights Act for the government to address such declarations either through primary legislation or by way of a remedial order. And again, my lords, given how well the declaration of incompatibility procedure is working and has worked in the past, I respectfully submit that there is no reason for us to innovate on that basis. These amendments are therefore not necessary. They are also, I submit, inappropriate in that they attempt to legislate for parliamentary procedure in this matter. The declaration of incompatibility procedure works well to strike the right balance, and there is no reason to upset it. My lords, I was addressed on the subject of the remarks made by the Lord Chancellor to the Joint Committee on Human Rights, and as your lordships have said, and indeed it was predicted that I would refer to this again, and I will, but the Lord Chancellor recently set out in his letter to the Joint Committee that while it is a fundamental tenet of modern human rights that they are universal and indivisible, it is legitimate to treat people differently in different circumstances. For example, a citizen may be legitimately treated differently and have different legal rights from a non-national, recognizing that there is a difference between a citizen and a non-national. And the Convention, as interpreted by the case law of the European Court of Human Rights, recognizes this principle in full. There is nothing in this bill that deprives any person of any of their human rights. In accordance with Article 1 of the Convention, we shall continue to secure to everyone within our jurisdiction the rights and freedoms defined in the Convention. What we can do legitimately, and what we are doing, is to draw legal distinctions between those with a legitimate right to be in this country and those who have come to this country illegitimately. My Lords, as I say, the provisions in the bill, while novel, are not without precedent, and we are satisfied that the bill can be implemented in line with the Convention rights. I would therefore ask noble Lords to withdraw their amendments.
I'd like to thank my noble friend, the Minister. I'm very grateful to him for his courteous and thoughtful reply on my amendment. I'd also like to thank all noble Lords who spoke in this debate. We've had a very refreshing, as others have commented, debate, and it's been very spirited too. We all share a commitment to the rule of law and a respect for the rule of law, but we differ over the interpretation we give to that and the weight we give to the different parts of our constitutional powers: government, the judiciary and Parliament. I'd like to thank especially my noble friend Lord Frost for reflecting on the continuing tension between laws made in this Parliament on the express wish of the people of this country, which command popular support, and laws made elsewhere, very often originating from different times to apply to different circumstances. I understand, though, my noble friend is keen to reject this amendment, but I hope that he will reflect further on one of the aims of this measure, to prevent legal challenge to removing people who come to this country illegally to Rwanda, and also to ensure that we do indeed operate a deterrence to stop the ghastly tragedies we see too often in the Channel.
Is the noble lady seeking to withdraw the amendment?
Yes.
Your Lordship's pleasure that the amendment be withdrawn. Amendment by leave withdrawn. Amendment 18, Baroness Chakrabarty, not moved. Amendment 19, Baroness Chakrabarty, not moved. Amendment 20, Baroness Chakrabarty, not moved. Amendment 21, Lord German, not moved. Amendment 22, Lord Everton.
So I rise to move this amendment and related amendments, which I have tabled, 24, 26, 28 and 30. I'm extremely grateful to those who have co-signed all or some of these amendments, in particular Noble Lord Cashman, the Noble Baroness Lady Butler Sloss, and the Noble Baroness Lady Bainton. I shall speak very briefly about this because I've spoken previously about it both on second reading and on committee. The current version of Clause 4 enables an applicant to oppose removal to Rwanda on the ground it's not a safe country for the applicant, but only if the applicant provides, I quote, compelling evidence relating specifically to the person's particular individual circumstances. That's end quote. Similarly, Clause 4.4, which relates to the ability to obtain interim relief for removal to Rwanda, depends on particular individual circumstances relating to the applicant in question. Now, the defect in these provisions, which is a very basic defect, is that no provision is currently made for those applicants who come within one of the important categories of refugee defined in Article 1A2 of the 1951 Refugee Convention. Now, that category comprises those applicants who have a well-founded fear of persecution because of their membership of a particular social group. Now, you can immediately see the difference between other categories of applicant under the of refugee under the Convention, who are individual persons, and this category, which is probably the largest category, or certainly the most important category, which comprises a large number of people who fall with and qualify as a refugee because they are members of a social group. And yet when we look at Clause 4, and I mentioned Clause 4.1 and Clause 4.4, dealing with interim relief, there is no reference whatsoever to group. So one particular category of refugee has simply dropped off the list completely. Now, the proper approach of courts and tribunals to such a refugee was described in detail by the Supreme Court in H.J. Iran against the Secretary of State for the Home Department, and H.T. Cameroon, again against the Secretary of State for the Home Department, the 2010 decision of the Supreme Court, especially in the judgment of Lord Roger of Earlsfree. I'm not going to take the House through the case in detail. It's sufficient if I briefly say that the approach to be taken, as established by that case, is that if the applicant for asylum claims to be part of or a member of a particular social group, the other members of which have a well-founded fear of persecution, then the applicant is entitled to be considered a refugee provided that they satisfy the particular decision maker that they are a member of that social group. Now, this H.J. Iran and the other case I mentioned concerned men who wanted to live an openly gay life, but would have faced persecution in their home country had they done so. But the principle of that I just described, of the way to treat this particular category of refugee set out in H.J. Iran, applies across the board. It's not limited to people who are LGBT. It applies to those who are members of a particular social group because of maybe ethnicity or gender or religion, who hold a particular religious or a particular political belief. So, for example, by way of analogy with those who did apply, the LGBT men who did apply in H.J. Iran, if people hold particular philosophical or political or religious views which they have not expressed because of a real risk of persecution, but would like to do so and want to live a life where they can express those views, then they are to be treated as members of a social group and to be granted the status of a refugee accordingly. And as the noble Baroness Lady Chakrabarti said at committee, the bill presents us with a false dichotomy. On the one hand, it's all about me, the claimant, the individual, and on the other hand, about Rwanda generally. The former, the bill says in Clause 4, allows you to make a claim for interim relief or removal generally to Rwanda, but the latter does not. But in between those two extremes, there is the category of a group, a member of a social group with a well-founded fear of persecution. This is not a torpedo point. This is not intended in any way to undermine or delay this particular legislation. But it is a reflection of the omission of a basic category of refugee defined in the Convention, and an extremely important category as well. On that basis, I beg leave to move.
My Lords, Clause 4, page 4, line 12, insert the words on the marshalled list.
The Chair. My Lords, I put my name to the 4 amendments of the noble and learned Lord Etherton, and I support everything he says, and since we're at report, I don't propose to add to it. But what I also have is an amendment of my own at Amendment 42, and I declare an interest as the co-chairman of a parliamentary group on modern slavery and the deputy chair of the Human Trafficking Foundation. And I spoke to this at committee, and quite simply, taking on what the noble and learned Lord has just said, this is a very special group of people who are in this country not because they have chosen to take the boat trip, but because they have been brought here either by boat or by lorry or by some other route, and they are victims. So when one starts complaining about people who should have stopped in France because France is a safe country, it absolutely does not apply to victims of modern slavery. They are here on an involuntary basis, and they need to be regarded in a totally different way. I've heard endlessly, since I've been opposing much of the Rwanda Bill, of what is it that you or other opposition would do to improve the situation of those crossing the Channel. I deeply regret those crossing the Channel, and I don't have an answer, but I don't believe the need to stop people crossing the Channel in a dangerous situation is any reason to pass an utterly shocking bill. It's constitutionally incorrect and not looking at genuine victims, such as those victims of modern slavery. And it is no answer to those of us who cannot accept what is going wrong in this country and what is going wrong in this bill, that because we can't offer an answer to the people crossing the Channel, therefore we should be disregarded. My Lords, the victims of modern slavery, one of the most shocking crimes, making vast sums for perpetrators across the world, about probably a third to half of whom come to this country. And quite simply, the government is ignoring the plight of this most vulnerable group of people. And so I do hope they would, at this last moment, just think again about victims of modern slavery.
It's a pleasure to follow the noble and learned lady, Lady Butler-Sloss. Before I refer to the amendments in the name of the noble and learned Lord Etherton, I wish to raise a mention of Amendment 25 in the name of my noble friend, Lord Dubbs, and the Lord Bishop of Winchester. Sadly, Lord Dubbs cannot be in his place, but I did raise this issue in another amendment at committee stage, and it is our concern about freedom of religious belief or beliefs and the effect that Rwandan legislation could have on such beliefs, and particularly minority religious beliefs.
and the conflict that could arise with the Rwandan blasphemy law. But I'm sure that the Right Reverend Prelate, the Lord Bishop of Winchester, will say more on that. My Lords, I now turn to the amendments in the name of the noble and learned Lord Etherton, and he's made a powerful case for the amendments in his name and others within this group. I have also added my name to those amendments. From second reading onwards, my Lords, we have repeatedly made the case for these amendments, and I will not return to the same arguments, pertinent and important though they are. The government insists that belonging to this particular social group, being LGBT, would pose no threat in Rwanda because there is no discrimination in law. But, my Lords, there is no clear protections against discrimination or persecution within law. I refer your Lordships to the comments that I made and read into the record from activists in Rwanda who detailed their direct experiences of societal discrimination which directly affect them and their quality of life. To put it in context, my Lords, following the genocide, the abiding principle followed by the Rwandan government has been the principle of countering what is known as divisionism, ensuring that groups do not arise and are not pitted one against the other. The genocide informs the approach to governance, and that means, my Lord, in effect, conformity. And if you do not conform, it can be represented, and regularly is represented, as created divisionism that would have further consequences and is punishable by law. I give way to the noble Lord.
Giving way. The characterization he asserts as to the mentality in Rwanda does not reflect that of the community representatives whom the JCHR met last week. And it's clear from the evidence that they gave us that Rwanda is very much a leading light in East Africa as to being an open and tolerant home for LGBT plus people. And indeed, it's somewhere that it's very much felt in the region that gay people are at home. And I do not accept the characterization that he sets out. And I would encourage him to think again about the welcoming nature of the society in Kigali, particularly given what's going on in neighbouring East African states, for example, in Uganda and in the DRC.
The noble Lord for that considered intervention. I can only speak according to my experience, my direct experience from 2008 in Rwanda. As I said earlier in discussion of another grouping, I worked within Rwanda for several months as the chief election observer for the 2008 elections. At that point, I had to intercede on behalf of activists who were directly experiencing discrimination. I haven't given up on that. I recognise what is going on in Uganda and other countries, but comparisons are not always helpful. Indeed, they are somewhat odious when it comes to the lived experience of people who I am in direct contact with. This is not academic, I say to the noble Lord. What I'm talking about is what is reported to me as he is referring to what was reported to him and other parliamentarians on a parliamentary visit. So, my Lords, I therefore, following on from my previous references to divisionism and the consequences caused by one group against another, I therefore assert, my Lords, that LGBT people could not live openly because to do so would be a challenge to others and it would not be accepted. Indeed, it would be and could be portrayed as divisionism. This is in direct contrast to the protections that arise from the judgment referred to by the noble and learned Lord Etherton, H.J. Iran from the Supreme Court of 2010, and affects characteristics arising from belonging to a particular social group.
My Lords, again, I refer to the intervention at committee where I represented some of the concerns of LGBT activists, and I will not repeat them again, but if members of your Lordship's House request me to do so, I'm more than happy to oblige. At the end of last week, my Lords, I again made contact with LGBT activists and asked again, what was the situation like for LGBT asylum seekers in Rwanda? The reply, my Lords, was succinct and stark, written in 4 separate messages so that it could not be connected or traced. I quote, "Rwanda is not a safe place for LGBTQ asylum seekers at all." Second line, there are no laws. Third line, community is facing, fourth line, so much violence and discrimination. Starkly put, my Lords, Rwanda is not a safe place for LGBTQ asylum seekers at all. Though there are no laws, community is facing so much violence and discrimination. They are not my words, my Lords. They are the words of people living there, people in that region. That is the reality of life for LGBTQ people that we send to Rwanda, and sadly not the representations made to visiting parliamentarians.
My Lords, I rise to support Amendment 42, tabled in the name of the noble Baroness Lady Butler Schloss. My Right Reverend friend, the Bishop of Bristol, regrets that she cannot be in her place today to speak in support of this amendment, which she has signed. The question of deterrence is central to the government's premise in this bill. The threat of being removed to Rwanda should, in theory, be sufficient to discourage asylum seekers from taking dangerous crossings in small boats across the Channel. Even if we accept that this will work, and I have not seen evidence which suggests that it will, but even if we do accept that this will work, for individuals who are trafficked to the UK against their will, how can the bill possibly have a deterrent effect? This point was made repeatedly during committee stage, but has not been adequately addressed. There are as many as 4,000 people in the national referral mechanism who potentially could be eligible for removal. Can we not give them assurance that we will not subject them to further upheaval? The Global Slavery Index estimates that the rate of modern slavery in Rwanda is more than twice as high as the rate in the UK. Can we be sure that victims will be safe from the risk of re-trafficking? The provisions of this bill are incompatible with protective obligations, but potential victims won't even be able to put this injustice to the courts under the Rwanda Treaty. Not identifying victims or sending them to another country before their claim has been properly assessed will also set us back in our efforts to bring perpetrators of modern slavery to justice. Victims are often the only witnesses of the crime. Without them, the case against perpetrators will be significantly harder to make. Safeguarding victims of modern slavery from removal to Rwanda will have a negligible impact on the supposed deterrent effect of this bill, and every effect on the safety and flourishing of the victims of modern slavery.
My Lords, my name would have been to Baroness Butler-Schloss's amendment, but I was not quite agile enough to get in as number 4. The treaty provides at Article 13 that Rwanda shall have regard to information provided about a relocated individual relating to any special needs arising from their being a victim of modern slavery or human trafficking, and shall take all necessary steps to ensure that needs are accommodated. Those are the words. It does occur to me that if the Home Office rushes through its processes, as it will under the legislation of 2022 and 2023, I doubt that individual needs will be adequately identified, because it's hard enough to do even under the pre-2022 procedures. But of course, what Rwanda is told is necessary and what it actually can provide are, as has been covered pretty fully today, necessarily the same thing. Its record is not exemplary. The 2023, so just last year, US Trafficking in Persons report tells us it did not report referring any victims to the services. That there were none is, to me, literally incredible. The report refers also to widespread cultural prejudice, as we've just heard, along with a lack of capacity and resources which inhibit effective procedures, and so on. My Lords, referring to the words of the treaty as if that actually made them happen seems to me to be simply an extension of the argument that the legislation says Rwanda is safe, and therefore it is safe. So I ask the Minister what assessment the government has made of the risks of Rwanda being safe in this respect, what assessment it's made of the its capacity to provide services, whether it accepts that Rwanda is able carefully to assess each individual's risk of being re-trafficked. The risk in this country is enough. My goodness, what must it be there? Indeed, what assessment has it made of how it came to be that excuse me, those people who were sent to Rwanda by Israel disappeared? Common sense gives me a likely answer.
Very good. My Lords, I rise to speak to Amendment 44 in this group, which is in my name, and supported by the Noble and Gallant Lords, Lord Stirrup and Lord Houghton of Richmond, and the Noble Lord Kerr of Kinlochard. My Lords, before turning further to Amendment 44, I should say that I support the amendments in the name of the Noble and Learned Lord Etherton, and the amendment in the name of the Noble and Learned Baroness Butler-Sloss. I have had the benefit of hearing these amendments supported by them in committee and today in your Lordship's House. I don't plan to say anything further, but certainly in relation to those who have been trafficked or are the victims of modern slavery, I cannot for the life of me understand why the government's attitude to such people should be that they were in control of their own decision making when manifestly they were not, and categorise them as such. My Lords, I support also the amendment in the name of the Noble Baroness Lady Meacher, the amendments rather 31 and 32, which I'm sure she will speak to immediately after I sit down, and the amendment in the name of my noble friend Lord Dubs, number 25. My Lords, as the explanatory statement in relation to Amendment 44 makes clear, the clause proposed by this amendment would exempt from removal to Rwanda people who are in a very special case. Those who put themselves in harm's way in support of Her Majesty's Armed Forces or through working with or for the UK government overseas, and extends this exemption to their partners and dependents. My Lords, in committee on February the 14th, responding to the debate on this amendment, the Noble Lord the Minister said at column 288, and I read this short: "Of course, we greatly value the contribution of those who have supported us in our armed forces overseas, and we have accepted our moral obligation. Anyone eligible for the Afghan Relocations and Assistance Policy and Afghan Citizens Settlement Scheme should apply to come to the UK legally under these routes. As regard the specific case of British Council personnel, they are qualified under the third pathway of the ACRS, and places are offered to them." My Lords, I know and I admire the Noble Lord the Minister, and he is correct, but his restatement of the eligibility framework and criteria for these schemes does not engage, never mind undermine, the necessity for this exemption. It's clear that we have a moral duty to those who have served at our behest and in our interests. However, despite serving shoulder to shoulder with British troops, most of the triples were not evacuated in August 2021, and subsequently many have been rejected under the ARAP scheme. We know now that they were rejected because of misunderstandings on the part of decision makers of the terms of ARAP, the nature of the service of the applicants, often despite the existence of compelling evidence to the contrary, and also there is now credible evidence suggesting that UK Special Forces Department blocked eligible applicants from being accepted. They are a group who were refused wrongly by the bureaucracy or blocked for self-serving venal reasons by the special forces of the country, whose government and ministers, out of moral obligation, promised them, and still does promise them, sanctuary. It comes to this. Many applied for the status that would allow them a legal route to resettlement in the UK. They were refused in error. Then, fearing what materialised as their comrades were murdered or tortured by the Taliban, they were faced with the choice to stay in Afghanistan and face certain death, or to get here somehow. They chose to get here somehow. They were in extremis, had no alternative. There was no legal route open to them because of our failures. In committee, my lords, I shared accounts of the experience of 5 Afghans who were driven to this extreme and acted accordingly. I don't intend to repeat them this evening, but they're freely available in open source and media, and I'm sure there are many others that will become apparent over time. Responding to this amendment at committee stage, the Noble Lord the Minister asserted that, and I quote, "Regardless of the contribution they have previously made, a person who chooses to come to the UK illegally, particularly if they have a safe and legal route available to them, should be liable for removal to a safe country." The third clause of that sentence does, I think, make a rather startling admission, that the position of this government is that even when they have failed, that is, the government have failed, when access to a safe and legal route is wrongly denied, the consequences of their dereliction should doubly be laid upon those who are already victims of it in the first place. Your Lordship's House is a legislative chamber. Where there is a wrong that can be remedied via legislative means, we are empowered to do just that. Making law is not separate from morality, but in cases of this moral seriousness, should be a means of translating morality into practical, proportionate and enforceable measures. On the 5th of February, in debate on a UQ on the relocation of Afghan Special Forces, I welcomed, and I repeat that welcome today, the government's undertaking to review all the ARAP applications from members of the Afghan Special Forces, known as the triples, that already have been deemed ineligible. Some of these very brave men and their families and dependents are hiding in Afghanistan, others in Pakistan awaiting whether the new government in Pakistan will deport them back to Afghanistan, where they will be in danger of their lives. As I said then, in addition to those who are in Afghanistan and Pakistan, there are others who are here in the United Kingdom. In August 2021, when Kabul fell to the Taliban and chaos ensued around Kabul airport, they were denied access to evacuation flights. The Taliban in attendance around the airport knew who they are and where they lived, and soon, when the killing of their colleagues and families started, they were forced to get here by irregular and dangerous routes. On the 5th of February, I asked whether the Ministry of Defence, in carrying out the review, would undertake not to make them ineligible for ALAP simply because of how they got here. No such undertaking was given either then or since. Apparently, His Majesty's Government, while greatly valuing the contribution of those who have supported us and our armed forces overseas and accepting their moral obligation to them, nonetheless values the Rwanda policy more. My Lords, the provisions of the Illegal Migration Act are so unambiguous that if any got here with the assistance of traffickers and crossed the channel in small boats, they are illegal migrants. Section 1, subsection 2, paragraph A places a binding duty on the Secretary of State to arrange for their removal. In conjunction with the provisions of this bill, were it to enter into force, that removal would be to Rwanda, and some already have been threatened repeatedly with deportation to Rwanda. It is to remedy this that the amendment is necessary. In this context, I echo a question I asked in committee on 14th February. When we ask others to ally themselves with us in the future, as we will, what lessons do we imagine they will draw from these Arab cases? That we are steadfast in our support for those who have lent their support to us, that we can be trusted to meet our commitments. No, we will be seen as utterly transactional. A power that asks others to risk their lives and pledge themselves to act in our interests, but will not offer sanctuary in return when they need it. As I've said, I welcome the statement from the 1st of February that the MOD has decided to undertake a reassessment of all decisions of ineligibility made on applications with credible links to Afghan specialist units. But evidence of errors in handling eligibility for Afghan settlement schemes is not confined to the Triples and Arab. I refer your Lordships to the evidence compiled by the charity the Sula Alliance, whose spokesperson, Professor Sarah de Jong, has commented that their casework of interpreters and labourers who qualify under the ACRS being treated similarly by decision makers and full of errors. This amendment goes significantly further than the government's reassessment and meets the moral need. While I do not approve of the bill or its intentions, this amendment should attract support even from those who count themselves among the bill's supporters. If they wish the Rwanda scheme to work and be seen to work, this would at least ensure that we do not face the ignominy of seeing those who have risked their lives at our instigation being deported from the country in whose service they have risked exile, serious injury and death. Hello.
Having tried earlier in the day during questions to be supportive of the Noble Lord Minister, let me now seek to redress the balance. I have appended my name to Amendment 44 for two reasons. First, because I regard it as essential that we meet the obligations we have undoubtedly accrued to those who have supported the UK's overseas endeavours in the past. But equally, because we need to protect our ability to garner such support in the future. Support that will be crucial in many instances to the success and safety of our own armed forces. And it is for this reason that faster and better handling of currently outstanding issues, like those pertaining to the Afghans, will not of itself resolve the issue. Now, this bill has passed in another place and will undoubtedly become law. This amendment does not in any substantive way affect the powers and arrangements set out in the bill. It carves out a very limited exemption. Now, the government will undoubtedly argue that the more the exemptions, the weaker the bill. Maybe. But this, it seems to me, is a pretty important exemption. And that really is the question before your lordships. Would the harm done to the UK by not agreeing this amendment outweigh the impact that agreeing it would have on the government's objective of ceasing illegal immigration? The answer, it seems to me, is an overwhelming yes, and therefore I believe we should agree the amendment. The Noble Lord, the Minister, will undoubtedly disagree. My proposition to your lordships is therefore this. Let us pass the amendment and send the issue back to the other place, and let us then see what importance they attach to the safety of those who have hazarded their security and their very lives in support of global Britain's overseas endeavours.
It's an irrefutable case in my view. It's very odd when you think about it. We've had 3 days in committee. We've had a long second reading debate. And the government have had nothing from us which is of any interest to them. There are no government amendments on the list today, not a single one. And the government has shown no signs of picking up, improving, adjusting, taking advantage of any of the amendments tabled by anyone all around the House. I'm tempted to say it's rather contemptuous. We've taken their bill seriously. I'm not sure that they've taken seriously what we've said about the bill. But now we come to the test, because this particular group contains nothing which would in any way detract from what it is the government are trying to do. And having heard the noble and Lady Butler-Sloss's explanation of the modern slavery amendment, that it cannot be right to treat the victims of modern slavery as perpetrators. It cannot be right to penalise victims. Having heard the arguments advanced by Noble Learned Lord Efferton, who has drawn attention to what clearly is a lacuna, not a large lacuna, but a real lacuna in the bill. Having heard the Noble Lord Brown explain what seems to me to be a debt of honour, it wouldn't cost the government very much to say, okay, we've heard you. We're prepared to, maybe we want to adjust your wording, but we're prepared to incorporate your thoughts. Because you have hit on 3 real points, not seriously damaging to our bill, and points where our changing our view would be the honourable course to take. I very strongly support Lord Brown's amendment. The service that I was privileged to lead is a small service which employs, in my time it employed more than 10 locally engaged staff for every single member of the diplomatic service in our high commissions and embassies around the world. The vice consuls, the clerks, the drivers, the security guards, the messengers, many of them work for us for a lifetime. In certain countries, at certain times, having worked for us puts them in grave danger. One thinks nowadays of Russia and Belarus, of Iraq, of Iran, and of course of Afghanistan. I strongly support the case for doing the right thing to those who have assisted our military. But I think those who've assisted our the Queen's servants, the King's servants on the ground in diplomatic missions without diplomatic immunity, and now as a consequence are at risk, deserve the same degree of support. It's a matter of honour not to pick up Lord Brown's amendment would be dishonourable.
Yeah. My Lords, I strongly support Amendment 44 in the name of Lord Brown of Ladyton, to which I would have been more than happy to add my name had there not been a limit of 4 people, 4 sponsors for each amendment. One of the groups of Afghans to whom this exemption would apply, as we've already heard, would be the interpreters who worked with the UK Armed Forces in Afghanistan, whose predicament at the hands of the Taliban I've been highlighting in your Lordship's House for over 10 years now. Many thousands of Afghan interpreters, I'm happy to say, have succeeded in being relocated with their family members to the UK. But there are others whose claims under the various schemes have been unfairly or inexplicably rejected and who still live in fear, as do their family members. Only 2 weeks ago, I was contacted by one of these who had worked as an interpreter and translator, and who, because his whole community in Afghanistan he said it was common knowledge in this community that he had been working for the British, so he felt forced to flee to a third country where he is now living in hiding in fear of his life with his mother and younger brother. Now, the importance of this proposed new clause to this individual and others like him is that his application under ARAP was refused on the grounds that he was not directly employed by HMG. His employment as an interpreter and translator was with a global agency under a contract that organisation had with DFID to provide translation and interpreting services to the armed forces and to UK government projects in Afghanistan. So he, I think, would clearly fall under the terms of Section 1B of this new clause, talking about indirect employment, and his family would fall under Clause 1C. To me, he appears to be typical of the brave linguists who worked with pride for the UK, but who in the end may feel forced to seek access to the UK by what would be treated as illegal means. No way should he then have to face the indignity of being further removed to Rwanda. His loyalty is to the UK. I am equally concerned about those who worked for the British Council and also the so-called triples, who Lord Brown has mentioned already. Some of these Afghans are also in hiding in fear of kidnap, violence and death threats at the hands of the Taliban, and if forced to seek asylum here other than through an official route, also deserve our gratitude, respect and protection. I appeal to the Noble Lord the Minister to accept this amendment and also to undertake to review all Arab rejections, not just those of the triples.
My Lords, this group, similar to Group 3, demonstrates the risk to individuals where their safety due to their individual circumstances cannot be properly considered under this bill before they are sent to Rwanda. And we've had a focus on LGBT, we've had a focus upon modern slavery, and a focus upon Afghans and people who serve this country. My noble friend Baroness Hamway raised the issue of modern slavery, and undoubtedly this is an area where there is a lacuna in the bill, because these people are victims. And my noble friend asked for the government to do a complete analysis of the way in which they deal with this group of people, to understand what sort of facilities they are going to meet, but more importantly, to be able to make the assessment here, to understand that these people are suffering and victims, and that therefore their case is heard, so that you can judge that victim base. On the other hand, we've been talking here about the armed forces and their families, and this carve-out for Afghans. It is not correct to assume that those at risk to their association with UK forces have all been brought to the UK through safe routes. I think it's quite clear from the debate that we've just heard that there are many who remain and have no alternative but to either go into hiding or to see their life threatened, but also to take dangerous routes to reach safety in the UK. The country who they believed will protect them for all that they have put their lives at risk for. There are just 2 points that I'd like to make to supplement that. The evidence from the UNHCR to the Supreme Court detailed that citizens of Afghanistan had 0% success rate for claims processed in Rwanda between 2020 and 2022. During that same period, 74% of Afghans who came to the UK had, in that time period, had their claims processed successfully. So I asked the government, to what extent will the risk of Afghans due to their association with Allied forces in Afghanistan be both understood and both be considered in Rwanda? This issue raises the discharging of our responsibilities towards these people who are placed at risk because of the UK associations and not given protection by the UK, but sent elsewhere for another country to deal with, a country which has a 0% success rate for giving people asylum in that country. These are people who put their lives and those of their families at risk in support of our UK enterprise and our forces in that country. So, my Lords, this group of amendments needs to be examined further. It needs a much more sympathetic approach from the government. because we are talking about victims here, we're talking about people who are serviced to this country. And these people need to have a special treatment. And this, rather than just simply looking at the legislation and passing them through. Can you imagine, my lords, if somebody from Afghanistan who got to this country, who would have qualified if they had had the chance, or who have had their qualification misrepresented for whatever reason, being sent to a country which has a 0% chance of them being recognised as a refugee. So I think what this group of amendments have done is to demonstrate that there is a risk which the government has to pay attention to in trying to make sure that they fulfil the requirements which I think are both humane and also important.
My Lords, as we come to the end of today's consideration of this bill before us, can I just start with mentioning what Lord Kerr mentioned, because I think it's an important point. I raised it in the first debate, in the first group of amendments, when I said the constitutional position is that the government has the right to get its bill through. But this House of Lords also has a constitutional position, which is the right for it to expect that its views, that the amendments that it passes are considered properly by the government. I have to say, and I agree with Lord Kerr if I've got it wrong, but I think what Lord Kerr was saying, certainly what I think, was that it's our belief that the government is simply saying we're not going to change the bill at all. We don't mind what amendments, we don't mind what inconsistencies are brought forward, how illogical what we're saying is. Such is our determination, we're going to drive this through and use our electoral majority to do it. And to that extent, I say to the government, you are undermining the constitutional conventions on which our Parliament is based. Because, of course, I've been lectured, and many of us on this side of the House, and indeed across the House, have been lectured on the government's right to get its bill through. Indeed, the Home Secretary was at it again this morning in the newspaper, warning of the consequences of us not allowing the bill through. I say to the government, why do you simply ignore what the House of Lords is saying, which appears to be the intention? May not be the intention of Lord Stewart, may not be the intention of Lord Sharp, but it'd be interesting to see what, if any, amendments the government make in response to what has happened in your Lordship's House through committee, but more importantly through the votes that have taken place today. And I would appreciate us having some understanding of what the government's view of what is being done here. Because I think, as Lord Kerr mentioned, and I'm sure many other noble lords feel, is we have a right to be heard and at times those amendments to be acted upon rather than simply ignored and dismissed as people who don't understand the problem are simply trying to get in the way of dealing with the boats. So I start with that because I think it's a really important point, notwithstanding the fact that, of course, this group of amendments, and with many other groups of amendments, have made some really important points that reflect on the bill. Because this part of the bill, this group of amendments deals with, obviously, with individual claims and exemptions that may be made with respect to the general principle of the law. It's always been my understanding, as somebody who has great respect for the law, although not a lawyer myself, that any good law, there are not many laws that don't have exemptions within them. Because actually, a good law may have a generality of application to the population, and Lord Stewart will know this better than me in his current position, but they have exemptions within it because the impact of a general law on an individual may be such that justice is not served. And because of that, therefore, law has to have exemptions within it and built into it. And as it stands, the government are simply not able to have any exemptions within it. It is simply a blanket application of the law to particular individuals, whatever their circumstances. And we've had three very passionate and moving move as leading the amendment. Lord Etherton, supported by my noble friend Lord Cashman, outlining the particular circumstances that may occur with a particular social group. Lord Cashman in particular mentioning the LGBT community, but Lord Etherton will appreciate that and so on. Is that something that needs to be considered within the bill? We'll have to see what but the government appears to be another one that the government will just dismiss. We then had the noble Baroness Lady Butler-Schloss with her amendment with respect to victims of modern slavery and trafficking. People who are trafficked have they don't say, yes, traffic me, help, that's smuggling. We're talking about people who are trafficked, people who have no part in the decision. And the government's bill at the moment just says, well, we don't care about that. Those people will be subject to automatic deportation or going to Rwanda. And what Lady Butler-Schloss has quite rightly said, surely that should be something that could be considered for exemption under the terms of the bill. And then we had Lord Brown's amendment, supported by Lord Stirrup and others, pointing out that the consequence of the bill as it stands will be people who serve this country, put their lives on the line for us, will simply be treated as illegal in this country and deported to Rwanda. Does the Minister think that's right? Does the Minister actually agree with that? I mean, it'd be interesting to know whether Lord Sharp thinks that somebody, as Lord Brown pointed out, who has fought for this country, served with this country, put their lives on the line for this country, who has had to come because of the situation that Lord Brown outlined with respect to themselves in Afghanistan, finds himself in the country, who in this House believes that they should be deported to Rwanda? I don't believe the government front bench. It's a rhetorical question, I'll save Lord Sharp that, but I don't believe the government front bench think that. I just don't. Well, if they don't think that, sort it out. That's the point. We're not playing at this. These are things that affect real people's lives. And the point that Lord Stirrup made is a really important point. What credibility will this country have if it finds itself in a similar situation in the future and says to people, work with us because we will ensure you are protected? What possible credibility would we have as a country or as part of an alliance saying to people, we will protect you, if you serve in this country, do not worry, the consequences of it, you will be protected from? What will we be able to say to them when, as Lord Stirrup points out, they simply turn around and say, that's not what happened in Afghanistan. That's not what happened with those of us who served there. Many of us were forced to stay. And the consequence for that, as we know, has been for some of them, I'm sure that the consequences have been very severe. So Lord Brown's amendment is an amendment where the government needs to act. We don't need warm words of, yes, we need to consider this and think about it. It's a very important, interesting point that's been made. The government make the law. With respect to this, change the way the bill is to ensure that those people are protected. Change the bill with respect to the way that Lady Butler-Schloss has outlined with respect to victims of modern slavery and trafficking. And again, as Lord Etherton and Lord Cashman say, the bill needs changing, although I noticed that my noble friend's Amendment 33, which we're going to consider on Wednesday, may actually be a way of doing that, but we'll leave that to the debate on Wednesday. So this is a very important group of amendments dealing with individual claims and exemptions. This isn't only about the law, it's about the justice, the way that justice works in this country. And justice demands these changes, and I hope the government responds.
My Lords, these amendments go to the issue of whether it is safe to relocate a person to Rwanda for particular individuals. It remains the government's view that these amendments are not necessary, and I will set out again the government's case. Before I do, as to Lord Kerr's comments, as regards your Lordship's amendments, I obviously can't preempt what the other place will do or what that will prompt, and I'm sure noble Lords will understand that. Amendments 22, 24, 26, 28 and 30, tabled by the Noble and Learned Lord Etherton, would undermine one of the core principles of this bill, which is to limit the challenges that can be brought against the general safety of Rwanda. The government does not accept these amendments are required to safeguard claims against removal to Rwanda on the basis of an individual's LGBT identity, or indeed for any other characteristics such as religious belief. These amendments would unnecessarily and significantly broaden the bill's provisions. The bill provides appropriate safeguards to ensure decision makers will make a case-by-case decision about the particular circumstances of each case. The bill also allows decision makers and the courts to consider certain claims that Rwanda is unsafe for an individual person due to their particular circumstances, despite the safeguards in the treaty, if there is compelling evidence to that effect. As in all cases, decision makers will make a case-by-case decision about whether the particular circumstances of each case would mean an individual would be at real risk of harm were they to be relocated to Rwanda. That consideration would include an assessment of whether individuals face a real risk of harm as a result of their sexuality. Furthermore, for LGBT individuals, that consideration would include any assessment of any compelling evidence reviewed in line with the principles outlined by H.J. Iran, to which many noble lords have referred, that being LGBT would mean that Rwanda was not safe for them in their particular circumstances. As we've previously set out, the Constitution of Rwanda includes a broad prohibition of discrimination and does not criminalise or discriminate against sexual orientation in law or policy. Rwanda has assented to international conventions and continental frameworks that protect the human rights of all citizens, including the UN Declaration on Sexual Orientation and Gender Identity and the UN Report on Sexual Orientation and Gender Identity LGBT populations. Rwanda is also a signatory to the 20...
Could the Noble Lord tell the House what legal provisions are in law, particularly for the T part of LGBT, that are actually on the statute book in Rwanda?
No, I can't. I'll have to come back to the Noble Lord. Rwanda is also a signatory to the 2011 United Nations statement condemning violence against LGBT people and has joined 9 other African countries to support LGBT rights. As part of the published evidence pack, the updated country information note gave careful consideration to evidence relating to treatment of LGBT individuals in Rwanda. I would also say to noble lords that the Rwandan legal protection for LGBT rights is generally considered more progressive than that of neighbouring countries, as has been alluded to. Turning to Amendment 25, tabled by the noble Lord Dubbs, which relates to claims on religion or belief grounds being taken into consideration on whether Rwanda is a safe country. The amendment specifically mentions an individual's religion or belief, but the effect would be to permit the Secretary of State to consider whether an individual who is due to be relocated to Rwanda has any refugee convention reasons why Rwanda would not be safe for them, including on grounds of religion or belief. In effect, this would be considering a protection claim for a third country national whose home country is not Rwanda. A number of noble lords raised concerns about religious tolerance in Rwanda and sought to argue that it would be unsafe for individuals who followed minority faiths or had no faith at all. My lords, the government disagrees with this contention. Our policy statement and the country information note on human rights make clear, and as I set out in my letter following second reading, that the Rwandan constitution provides protection for individuals of different religions and faiths, as well as prohibiting discrimination on the grounds of religion or faith. Taken with the appropriate safeguards, which are set out in this bill and elsewhere in our partnership with Rwanda, decision makers will be in a position to consider the particular circumstances of each case, including where they involve an individual's religious beliefs. My lords, as I set out during an earlier debate, the bill, along with the evidence of changes and treaty, make it clear that Rwanda is safe generally, and decision makers, as well as courts and tribunals, must treat it conclusively as such. This ensures that removals cannot be delayed or frustrated by systemic challenges on safety. It's for this reason I cannot accept Amendments 31 and 32, tabled by the noble Lady Meacher. Amendment 31 would remove the need for the risk of harm when carrying out a serious and irreversible harm test to be imminent. If accepted, this would enable a court or tribunal to delay or prevent a person's removal to Rwanda based on a risk of harm that may not materialise for many months, if not years, after the person's removal to Rwanda. My Lords, this cannot be right. We cannot have a position whereby a person's removal from this country is prevented based on a risk that does not currently exist and may not exist until a significant amount of time has elapsed after the person is removed. My Lords, these provisions are consistent with the measures introduced in the Illegal Migration Act, agreed by this House last year. Imminent features in the European Court of Human Rights practice direction on interim measures. Clause 4.4 is not out of step with the Strasbourg Court. Amendment 32 would disapply Section 54 of the Illegal Migration Act, enabling the UK courts to grant an interim remedy preventing removal to Rwanda in cases where the duty to remove applies. This would undermine the suspensive claims procedure provided for in that Act. It risks vexatious claims being brought at the last minute in an attempt to frustrate removal, which would weaken the effectiveness of that Act. These amendments ultimately undermine the core principles of the bill, and the government cannot support them. My Lords, turning now to the position of potential and confirmed victims of modern slavery, the UK has a proactive duty to identify victims of modern slavery. We remain committed to ensuring that where indicators that someone is a victim of modern slavery are identified by first responders, that they continue to be referred into the national referral mechanism for consideration by the competent authorities. For all cases, steps will be taken to identify whether a person may be a victim of modern slavery. If a person is referred into the national referral mechanism, a reasonable grounds decision will be made. The amendment proposed would act to impede the provisions already passed in the Nationality and Borders Act and the Illegal Migration Act, which introduced the means to disqualify certain individuals from the national referral mechanism on grounds of public order before a conclusive grounds is considered. Furthermore, the amendment is unnecessary because it is important to be clear that the government of Rwanda has systems in place to safeguard relocated individuals with a range of vulnerabilities, including those concerning mental health and gender-based violence. If there is a positive reasonable grounds decision in a pre-Illegal Migration Act case, the provisions in Part 5 of the Nationality and Borders Act will protect the person from removal pending a conclusive grounds decision unless they are disqualified on the grounds of public order. As I set out in my letter to the Noble Lord Purvis, under Article 5.2d of the treaty, the United Kingdom may, where necessary for the purposes of relocation, and where UK GDP are compliant, provide Rwanda with the outcome of any decision in the UK as to whether the relocated individual is a victim of trafficking, and this includes positive reasonable grounds decisions. Under Article 13.1 of the treaty, Rwanda must have regard to the information provided about a relocated individual relating to any special needs that may arise as a result of their being a victim of modern slavery or human trafficking, and must take all necessary steps to ensure that these needs are accommodated. All relocated individuals, including potential and confirmed victims...
He's just said something at the dispatch box which actually isn't factually correct. He said that Article 13.1 says that trafficking and they must take all necessary steps. The treaty actually says and shall take all necessary steps, which are two very different things.
Is that correct? It sounds very moot to me legally. I said Rwanda must have regard to information provided about a relocated individual relating to any special needs that may arise as a result of their being a victim of modern slavery or human trafficking, and must take all necessary steps to ensure that those needs are accommodated. Sounds very much the same to me. All relocated individuals, including potential and confirmed victims of modern slavery, will receive appropriate protection and assistance according to their needs, including referral to specialist services as appropriate to protect their welfare. So it is simply not correct to assert that the government doesn't care. Finally, if despite those safeguards an individual considers that Rwanda would not be safe for them, Clause 4 of the bill means that decision makers may consider a claim on such grounds other than in relation to alleged onward refoulement, if such a claim is based on compelling evidence relating specifically to the person's individual particular circumstances, rather than on the ground that Rwanda is not a safe country in general. Turning to Amendment 44, tabled by the Noble Lord Brown of Ladyton and spoken to by the Noble and Gallant Lord Stirrup. My Lords, though this amendment is well-intentioned, it gives rise to the possibility that criminal gangs who operate in northern France and across Europe will exploit this carve-out as a marketing model to ensure small boat illegal entry to the UK. The terms agents, allies and employees will likely result in people who have arrived illegally falsely claiming to be former agents and allies as a tactic to delay their removal and completely undermine this policy's priority to stop the boats and promptly remove them either to their home country or a safe third country like Rwanda. My Lords, the government deeply values the support of those who have stood by us and our armed forces overseas. As a result, there are established legal routes for them to come to the UK. And for example, those who enlist and serve in His Majesty's Armed Forces are exempt from immigration control until they are discharged from regular service. After this time, non-UK HM Armed Forces personnel can apply for settlement under the immigration rules on discharge when their exemption from immigration control ends. There are also provisions for family members of HM Armed Forces personnel to come to the UK legally. Anyone eligible for the Afghan Relocations and Assistance Policy and the Afghan Citizens Resettlement Scheme should apply to come to the UK legally under those routes. But my Lords, I take what the noble Lord Brown and the noble and gallant Lord Stirrup say very seriously. And His Majesty's government does regret that so many cases need to be reassessed and that the MOD is taking the necessary steps to ensure that all future decisions are made in accordance with the enhanced guidance being produced for the review to which the noble Lord Brown referred. This was recently announced by the Defence Secretary, and while many members of the former members of Afghan specialist units, and including the Triples, have been found eligible under ARAP and safely relocated to the UK with their families, a recent review of processes around eligibility decisions demonstrated instances of inconsistent application of ARAP criteria in certain cases. In light of that, the MOD are taking the necessary steps to ensure that the ARAP criteria are applied consistently through reassessments of all eligibility decisions made on ineligible applications with credible claims of links to Afghan specialist units on a case-by-case basis. This review will move as quickly as possible, but we recognise that ARAP applications from this cohort present a unique set of challenges in assessing their eligibility. It is the case that these units reported directly into the government of Afghanistan, which means that HMD does not hold employment records or comprehensive information in the same way that we do for many other applicants. It is essential that the MOD ensures this is done right and provides the opportunity for applicants to provide further information, which I know can sometimes take time from these individuals.
Will the noble Lord the Minister answer the question I asked in February when this review was announced? Will anyone who is eligible for ARAP, but was told they were ineligible and acted in the way in which a small number of them did, in extremis to protect themselves from possible death, will they be disqualified from being allowed to become eligible on review, and will they be excluded from the requirement of the Illegal Migration Act and this bill, if it becomes law, that they must be deported to Rwanda?
As I understand it, they will be deported to Rwanda. In conclusion, my Lords, the government of Rwanda has systems in place to safeguard relocated individuals with a range of vulnerabilities. The bill already includes adequate safeguards which allow decision makers to consider certain claims that Rwanda is unsafe for an individual person due to their particular...
I'm very grateful to the noble Lord Minister. But could I ask him, in relation to modern slavery, is there any law in Rwanda that protects those suffering from modern slavery or human trafficking?
I'm unable to comment on Rwandan law, but of course the treaty takes care of this, and I went into detail in that when I was making my earlier remarks. Under Article 5.2d of the treaty, the United Kingdom may, where necessary for the purposes of relocation, provide Rwanda with the outcome of any decision in the UK as to whether the relocated individual is a victim of trafficking, and that includes positive reasonable grounds decision. and under Article 13(1) of the treaty, Rwanda must have regard to information provided about a relocated individual relating to any special needs that may arise as a result of their being a victim of modern slavery or human trafficking, and must take all necessary steps to ensure that these needs are accommodated. So I'd have to answer the noble lady, Baroness Butler-Sloss, that at the moment I don't know whether they have those laws enshrined in domestic laws, but when the treaty is ratified, they will.
May I just say to the noble Lord the Minister, as far as I know, there is no legislation to that effect in Rwanda.
My Lord, may I ask the Minister if the review of Arab decisions will apply to the Afghan interpreters and translators and not just to military personnel?
Well, when I was explaining the Arab situation, I did point out that the difficulty of assessing and accessing some of the records, but I will certainly make sure that that is taken back to the Foreign Office, who, as I understand it, administer a large part of the ACRS, which of course is the treaty under which which is the agreement under which the Afghan interpreters come to this country. And I will find out the answer.
To press the noble lord, he won't be able to answer, but I would really appreciate if he could write a letter to me and let it to the House. The noble lord keeps referring to the treaty, saying that they must, and there is a difference between must and shall. In law, must is an absolute obligation. An absolute obligation. Article 3.1 says that they shall take necessary steps, not must. So will the noble lord write to me, because I've got the treaty here, and it says something different in terms of the copy that I'm reading to what he said now 3 times from the dispatch box?
Well, I'm better advised by my noble and learned friend, Lord Stewart of Delton. He tells me that must and shall both have a mandatory quality. But I will, of course, write to the noble lord on this subject. If there is compelling evidence to that effect, despite the safeguards in the treaty, decision makers will be able to consider certain claims that Rwanda is unsafe for an individual person due to their particular circumstances, as we have discussed a number of times. But I say again that these amendments are unnecessary, and on that basis I would invite the noble lord to withdraw his and urge other noble lords not to move their amendments.
I'm very grateful to the noble Lord the Minister for that analysis of the speeches that have been made and of the government's response to them. I'm very, very grateful to everybody else who's spoken in this debate, which I think has raised some really important points about people who are extremely vulnerable. I want to take up the point really first articulated by Lord Kerr, and also afterwards by Lord Coe, the noble Lord Coker, which is that really all of these amendments dealing with exemptions are objectively extremely reasonable and important, and do not involve huge numbers of people that would undermine the effectiveness of this proposed legislation. And the response of descending to detail to say they're not necessary, when I think, if I may say so, it's plain that they are necessary, it shows a certain lack of sensitivity, not only to the Chamber, but to a spirit of humanity, which should underlie the government's response. Turning to my own Amendment 22 and the consequential amendments, I find it difficult to understand how the government can justify dropping, effectively disenfranchising, one of the specified, expressly specified categories of refugee in the Convention. There is nothing in the policy statement or that was issued by the government when the bill was first published. There is nothing in the explanatory notes which says that they're going to do this. And I would have thought that in relation to refugees, dropping a specific category of refugee defined by this convention, which we have signed up to, is an extraordinary move. The justification seems to be that the government will not permit reference to groups because it would significantly enlarge those who are entitled to claim. If they are entitled to claim by virtue of a convention which we have signed up to, then the government must accept that. It must accept, like everybody else of the 149 states that have signed up to this. You can't simply say, well, we're going to ignore that category of refugee or that category of refugee. We're going to just rely on this category of refugee. There must be protection in one way or another, an ability for in one way or another for all of those who are mentioned as refugees to explain why removal would result in persecution and serious harm. Leaving that particular matter aside, I do want to comment on the intervention by the Noble Lord Murray on comments made by the Noble Lord Cashman about the situation of LGBT people in Rwanda. I don't want to go through this again, but I want to say that there are two factors which the Noble Lord Murray did not comment on, and in fact have never been commented on appropriately by the government by way of some sort of excuse in relation to LGBT people and the risks that they face of living an openly gay life in Rwanda. The first is that the travel information provided by the Foreign and Commonwealth Development Office remains the same as it always has done, as it was at the time of the Illegal Migration Bill, which is that there is a danger to LGBT people living openly as such in Rwanda. And secondly, and importantly, no reference has been made to something that I mentioned in committee, which is the report of the US State Department, the country report on Rwanda, which was published only 1 year ago, which talks about persecution and the possibility of physical harm to LGBT people. The government have never addressed those points at all. But I'm not going to go further into that. As to the others, I strongly support personally all the other exemptions, which seem to me to be reasonable, humane, and entirely appropriate, not designed to undermine this bill, but really rising to the level of morality which we should as a country display in relation to these categories of people. Having said all of that, and having heard the Minister, I think that the best thing that I can do would be to leave it to the amendment which will be put forward in the next category by Baroness Chakrabarty, tabled by Baroness Chakrabarty, which does contain reference to groups. And for my part, I think having had this debate will have been useful in honing the points that will have to be met in relation to that. And so on that basis, and that basis alone, I would beg leave to withdraw my amendment.
Is it your Lordship's pleasure that Amendment 22 be withdrawn? Amendment by leave withdrawn. Amendment 23, Baroness Meacher. Not moved. Amendment 24, Lord Etherton. Not moved. Amendment 25, Lord Dubbs. Not moved. Amendment 26, Lord Etherton. Not moved. Amendment 27, Baroness Meacher. Not moved. Amendment 28, Lord Etherton. Not moved. Amendment 29, Lord Coker. Not moved. Amendment 30, Lord Etherton. Amendments 31 and 32, Baroness Meacher. Not moved.
My Lords, I beg to move that further consideration on report be adjourned.
The question is that further consideration on report be now adjourned. As many as of that opinion will say content. The contrary not content. The contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.
Lords sound. House of 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 Lords sound.